Yes, please.
My lord, item 35.
35. It was earlier listed before this bench,
No, my lord.
coming for the first time.
My lord.
So what do you want, sir?
After vacation, my lord.
You are for the
Opposite party.
that you can't mention in after notice matter. You can't.
Counsel for the petitioner is also here. I have taken consent.
Yes. So what is your name, madam?
Adhyasha Annapurna.
Adhyasa. A. Annapurna. On behalf of Nitish Mishra.
Yes, madam.
You are Mr. A.K. Roy.
A.P. Roy.
A.P.
Right.
Roy. Amarendra Prasad Roy.
My lord.
Earlier A.K. Roy appeared or what?
My lord.
Earlier A.K. Roy name is there, so he appeared.
No, wrongly typed. Amarendra Prasad Roy, myself.
Along with
From the beginning.
after vacation?
My lord.
Why after vacation?
My lord, I have to prepare a memo of citations.
Memo of citation you don't prepare, you argue the matter.
I have to.
Without reading the matter, how can you prepare a memo of citations?
I have to.
ठीक है. Yes. क्या date करो तो after vacation? 30. Yes, next.
Item number 22. My lord, I am the petitioner.
Just a second. I'm getting there. No orders is passed out of turn. When the matter reaches, it will be passed. You are for the petitioner. Yes.
My lord, we have filed a memo for appearance by senior advocate Sri Jagannath Patnaik. That has not come on record so far. On 23rd, we have filed it.
Which for the other side? Anyone from this Mr. Rao Cham?
They had come, but they...
No. You are for the now, Mr. Senior Mr. Patnaik will appear for the petitioner.
Yes, madam.
You are Mr. Manoranjan Das.
Yeah.
But who is for the other side? Mr. C.A. Rao, Senior Counsel?
C.A. Rao, he was earlier here, and we also mentioned before him that we'll be seeking time.
So you have agreed for a date?
Yes, my lord. After vacation, my lord.
So
In
this
the
order will
first
be
week-
passed when it will be called. I hope any learned junior of Mr. Rao will be there. Date करो तो after vacation. 26? 26.
Grateful.
But in case they don't agree, it will not be allowed.
No, he is going abroad. He is going abroad. That's what he told. And, yes.
Sir, I am not party, sir. He has not shared his ticket with me so that I will know everything.
We'll
You know so
inform,
many things about so many, but I am only relevant in information I have to rely.
We'll inform.
Even if I know Mr. Rao is met me and told me that I am going abroad, I cannot record that. That you also understand.
We'll inform, my lord.
Yes.
Item 9, pardon.
Hmm.
Here, pleadings are completed. State is the other side. Let's keep it next week in a
Next week,
Yeah.
item 9.
Yeah.
Who is for the other side?
State is the other side.
The private opposite party is there. Sasibhushan Jena, Satyajit Behra.
I will inform it.
Without informing after notice matters, I cannot adjourn. They can't be preempted.
Yes, that is it.
So when do you want, sir? Item 9.
Yeah. Next week any day.
Debabrata Ratha, SS Mahapatra.
Yeah.
Apano to Debabrata ki diyo.
No, Mr. Ratha was here. He left for.
On behalf of Mr. Ratha.
Yeah.
When do you want?
Let's keep it next week. Any day.
Next week date na kebe gote date karantu. Ei chuti purburu gote karjo. Again?
8/5.
8/5.
One more prayer.
Yes.
That item 25, Mr. Himanshu Mitra is not well. Let's keep the item 25. Mr. Senior Advocate Mr. is not well. He requested me to adjourn the matter after vacation.
Yes. Who is for the other side? Item 25. So when do you want? Let it reach. If they object, it will be listed. When do you want, sir?
After vacation.
After vacation date dithan. 24/6.
As you also.
Pardon to mention, my lord.
Mr. S.S. Joshi.
SK Joshi.
SK. Yes, carry on, mention.
My lord, item 23, my lord. I am for the.
23.
Yeah.
Yes.
I am for the opposite party, Puri municipality, on behalf of PK Mohanty Senior Council.
So you inform the other side.
I have already taken consent and also.
No,
Inform.
if you have a written consent on a memo, you file it. Up to notice matters of
My lord,
2016,
in
I
this case,
cannot
we
urge
will file
that you
our
don't have to
count.
explain me, sir. I have no issues if both of you agree. Because I find that at the time of when the matter is called, they say that we did not, at least not for this period. So only it can be done in their presence when the matter is called, or if you have if this is present, or you file the written memo. No preempting the other side as far as adjournments are concerned.
In this,
My lord, item number
Who is for the other side?
Mr. Ansuram Misra.
You have informed him. You are
Yes,
saying.
my lord.
When
My lord,
your name, sir?
SK Sahoo.
You don't have power.
No, my lord. On behalf of PK Mohanty Senior Council. In this case, my lord, we will file counter.
Sir, I don't want what you will do, but I want that the matter should reach the 2016 matter. It should be taken up. After 9 years is enough time to file a counter. If you have not filed, you have chosen not to
But there is
file.
some
You must understand that. When do you want?
I want to after vacation too.
After the date current?
May I be allowed to make a mention, Your Lordship?
Yes, please.
It's a matter of 2020 where an order of local express.
Fresh matter.
No, it's a matter of 2020.
Give the memo.
Item 40, madam.
My lord, item number 6.
Who is mentioned? You're sorry. Item 6.
My lord, AD has not been returned. So may I pray, my lord, adjournment?
So the order has to be passed. If you're busy not to attend the court,
No,
please
I've-
request any of your friend. Please appreciate that.
Item 40, my lord.
You are Mr.
Soumya Ranjan Pati.
Order has passed. It is not back.
Item
Yes, call the list.
My lord, item 40, my lord. Item 40, my lord.
40. Yes.
Yes, my lord. My lord, Mr. Mohanty, my lord, he has some personal difficulty. May I pray, my lord, next week or a week after?
You are appearing for?
Appellant, my lord. I have informed the other respondent, counsel for respondent.
I am for the respondent, Miller.
Mr. Adimesh Mahanti. Respondent, Mr. Sahoo, you are there.
Yes, Miller, I am for the respondent, my lord.
Say.
Yes,
So-
short date, my lord. I pray for short date.
So please, I am not fixing a date. I want today. So please
Madam,
don't ask me for fixing. Yes,
Madam.
Mr. Mahanti and Mr. Sahoo, you agree for a date.
My lord, a week after on 15th, my lord, if 14th or 15th of May, if possible. My lord.
Yes. Mr. Sahoo, 14th?
Yes, my lord.
14th May?
My lord.
Yes.
Obliged, my lord.
Weekly list, item 1.
One for to be mentioned.
Yes. What has happened actually? File diyantu.
Yes. The stamp report has said that there is no delay, but in fact we have filed a petition for condonation of delay.
It is something else actually. That is something. So that draft order ta achi adhere. Good, ek to kishi nahi adhere. Just wait. ଆପଣ ନ ଦେଖିକି ହଁ ମାରି ଦଉଛନ୍ତି।
Stamp reporting.
So I find a order is already there.
Yes.
That IA2 stands dismissed as not pressed.
Yes.
So unless that is revived or you file another petition, it can't be done.
That will serve.
ये ଏବେ ଟିକେ ଛିଡା ହୁଅନ୍ତୁ।
It is asked for report of the SR, there is no delay. Delay is at flag B for further order.
Not that exactly.
That is,
ଆପଣ SR କପିଟା ଦେଖିଲେ ମୁଁ ଯୋଉଟା ଦେଖୁଛି ଏବେ
ଆଜ୍ଞା,
Note
ହଁ,
କରନ୍ତୁ, SR
order number 11 side ରେ।
ନାଇଁ SR କ୍ଲିକ୍ କରନ୍ତୁ, SR ବୁକମାର୍କ ଅଛି,
ହଁ ଅଛି।
ବୁକମାର୍କ ରେ SR ଟା କ୍ଲିକ୍ କରନ୍ତୁ। ମିଷ୍ଟର ମହାନ୍ତି, କିଛି ଦିନ ପରେ ଆଉ ପେପର ରହିବନି ସାର୍, ଆଉ ପେପର ତ ପଳେଇବ, ତେଣୁ ଆପଣ ଏଗୁଡାକ ୟୁଜ କରିବେ। ଏଥିରୁ ଏମିତି ତିନିଟା ରହିବ ଆପଣଙ୍କର ପେପରଲେସ୍। ପାଇଲେ SR ଟା ପାଇଲେ? ଲିମିଟେସନ
Yes.
ଡେଟ୍ ଅଫ ଜଜମେଣ୍ଟ 29/1/21।
There is delay. There is delay.
No, that's not that. I'm not drawing the attention. So that may be delay or may not be. But kindly mark then one. Just look at that SR stamp report.
Yes.
In time cross expired on no give no detail. So that is what. But the order has been passed that since there is no delay, it is not pressed.
So may
It's a mistake on part of SR.
No, may I play one thing?
You file another IA.
Another. Yes, exactly.
এটা কোর্ট রଖିବେ ড্রাফট ঠিক আছে ନାଇଁ ଅଲଗା ରଖନ୍ତୁ ତାହେଲେ because the order is correct.
Yes.
The order dated 22/4/25 ଏଟା ଦେଖ that day we understood it correctly. ଏଟା ଦରକାର ନାହିଁ ଆପଣ ସେଟା ଦେଇକି ଆସନ୍ତୁ ଯାହା order that the outer limit can be extended, that SLP is pending. Mr. Mahanti gave those. So the order is correct. But in place of a IA, I mean, in absence of a IA rather.
Yes.
So when signing this order, I checked the regarding the IA. So then I found that IA has been disposed of. Neha sunu seda. Mr. Sanjeev Swai AGA for appellant. Anyone appearing for the respondent?
I am for the respondent.
Mr. SK Jose.
For the sole respondent.
For the respondent? Yes, Mr. Joshi, that 60 plus 60, 120 days
120
limitation.
Days. Beyond 120
So that has been referred to the
Yes.
bench of the Honorable Supreme
Yes.
Court. It is pending.
Yes, that is pending.
But somehow this, I mean, it is our mistake. I have to, I can't pass on the buck. Let's say stating that not proper stamp reporting. It is submitted by the learned AGA that IA number 2 of 2022 was not pressed and dismissed. AGA for the appellant contempt. On by order dated 21/3/2024 by the coordinate bench. The learned AGA refers to the stamp report, which at para 1 does not indicate the period of delay. The COVID ରେ ଆସିଯିବ 1 ରୁ 31/12 Mr. Joshi, 1/12 ରୁ 31/12 COVID ରେ ଆସିଯିବ 29/1 ରୁ 31/12
Till then limits on hochi. Till then delay up to 49 days.
COVID period exemption जोटा in the contagion.
Yes, that.
So what is your
No, in fact, let's keep it. I will examine. Let them file a fresh IA, and whether it is covered under that COVID-19 guideline or not. Exactly.
It refers to the order dated 23/9/2020 passed by the Honorable Apex Court in S.M.W into bracket .P into bracket C number 3 of 2020 regarding exemption of period for the pandemic. 29/1/21 pandemic started in 2020 or 21? 2020. March. I think it will be covered.
That is the judgment of the Supreme Court. In view of that, the petition is to be filed.
Because Joshi कौन कि examine करो
Second.
किबे
Next week Q1 chapter.
वो डेट करंतु 7/5 कोड़िए
Provided they should come forward with the fresh IA seeking for conditional
दरकार नहीं आईए टा सही ग्राउंड रे जदि और लेखा है नी ऑर्डर रे dismissed as not pressed but it should have been written. It should have been written that the delay period they should have calculated and said that so that at least you get a hint that suppose it is just before because the date where Supreme Court has prescribed the period starting prior to that it cannot be condoned.
Yes.
After that also I think the last 31/12/2021 it can be condoned because it was after those second phase but it was still there.
So far, you'll also see the petition 2 of 2022, it is filed under section 5. Section 5 will not come into
That
this.
petition has
Since
gone.
there is
That is no
specific
more
provision
there.
under the Act.
I got
That
your point.
petition is
Certain
not
Act.
there.
So on that reason only that order was passed.
Yes.
So since they have not calculated, I cannot say how much delay and
Yes.
which period because
Let's
they
keep
should
it
say
there.
that this period
File.
total period is from the 29/1/21 to 31/12/21.
Yes.
That should have been done, but they have not done it. But it appears that it takes care of the delay.
So let them come up with the fresh size so that you'll also.
Phrase, how can I? How can I insist when Supreme Court directs that the period to be condoned and the
No,
ordinance bench
I
has
is there. How can it be delay be condoned, my lord?
IA has
In view of the statutory bar.
On the next
ଆପଣ
day,
ଦେଖିବାକୁ ପଡିବ ତାହେଲେ ଆପଣ ଦେଖନ୍ତୁ ଅର୍ଡରଟା କଣ ହେଇଛି
I am order देखी sir. सकाल देखी.
କଣ ହେଇଛି କହିଲେ
Last order टा जोड़ा.
In view of the report given by the stamp reporter, learned counsel for the state appellant does not want to
Want to
press
press
this
the
application.
Delay কথা କିଛି ଲେଖା ହେଇନି.
ଲେଖା ହେଇନି
ଆଜ୍ଞା.
ତ ସେଇଟା ତେଣୁ so ଠିକ ଅଛି but it is understood that IA was filed for is there any
That is
dispute
there.
that IA was filed for condonation? There is
So
no
that is there. But
Oh,
unless
then-
the in view of the either.
so ଆପଣ ଟିକେ examine କରନ୍ତୁ only that judgment is 29 January 2021 ଆପଣ ଲେଖିଛନ୍ତି ଆପଣ
ଆଜ୍ଞା.
ଆଉ valid presentation
No, you'll also see.
ଆପଣ ଆଜ୍ଞା କହୁଛନ୍ତି date
It was filed on 15/11/2021.
31/12/21 ହଉଛି valid presentation
And judgment was passed on
ଆପଣ note କରିଦିଅନ୍ତୁ
29/1/2021.
valid presentation is 31st December 21. In re contagion ଦେଖନ୍ତୁ ସେଟା ସେ ଯୋଉ Supreme Court everything is there they have referred but not
Yes, yes.
not presented to the court in a proper way କଣ ଲେଖିଲେ ତା ପୂର୍ବରୁ କଣ ଲେଖିଛ କରେକ୍ଟ ଠିକ ଅଛି ଏଟା ଅପଲୋଡ ହେଇଯିବ ଆପଣ ଜାଣିଯିବେ ତା ପୂର୍ବଟା ବି valid the date of judgment ତାର ଲେଖି ଦିଅନ୍ତୁ date of judgment 29/1/2021 the presentation 31/12/2021. Mr. Joshi, learned counsel for the respondents, I'll seek accommodation to verify the dates in light of the direction of the Honorable Supreme Court regarding condonation of delay. 7/5 कहले ना 7/5 is fine 7/5. So since the entire period is condoned, then beyond upon jota kuhnanti ki 120 days,
Yes.
that question doesn't arise here. All appeals across the board, wherever there is delay, has to be condoned. Earlier also there was statutory limitation.
Yes.
This outer limit of 60 plus 60. So that question of law will not arise here. If you strictly speak, I'm not strictly, in fact, doesn't arise because it has already been condoned by the apex court in the
In view of guideline,
in gui-
keeping
that,
with the COVID-19.
so moto PL. I think SMW is so moto writ petition.
Yes. So motor.
So moto, yes.
Item 2,
Yes, please.
Even though
You know,
your lordship,
the statutes you are relying, one is that Admiralty Jurisdiction Settlement, Maritime Claims, then CPC.
CPC, yes, my lord.
CPC and High Court rules is relevant.
That under the Admiralty rules, my lords.
Admiralty High Court rules.
Act and rules.
The High Court has framed.
High Court has framed.
High Court तक दिया उनके? सीधा कौन था? High Court rules out it. May I request your learned junior to find it out? Okay, let us not spend time in searching it. The body देऊन sir, दे देऊन.
Well, it may not be necessary because
Let us keep at hand. Actually, what is happening? So they start searching. Once you refer to a section, they start searching. And maybe I have this SEC online or both.
This is of 2017, so I don't know if.
So because so let so if I can
frame.
yes you provide that and also I can flag it in that book.
Don't know if that
A
is
flag did it.
available in that, my lords.
So that is how I did not find. Let me tell you why I have sent it.
No, because
The blue one, thicker one. And the interesting is the blue one is without any index. Still more interesting.
Lord, I am intervening. There is a High Court rules.
Yes.
Notification.
Mr. Nanda is showing
The
that.
notification I can take.
But our library and all these things have to be set in order.
Notification I am giving. For
Please.
High Court.
They are to be responsive to a courtroom hearing actually. That at times, I don't know why this sense has crept in. Yes. Please.
Even though the matter is being taken up for the first time by your lordship, but in our anxiety to impress upon your lordship the urgency of the matter, we have to a certain extent been placing on the case, and it has rightly been observed by your lordship in the last date that we need to address your lordship on the court fee issue, because that goes to the root of the matter. And that will decide whether the order of arrest, ad interim ex parte order of arrest made on the 19th of March should be allowed to be extended beyond today, and also whether the plaint at all survives or not. These are the aspects on which I will be addressing your lordship. My lords, we have prepared, submitted to your lordship a very elaborate list of dates running to 10 pages. But I will not bother your lordship with those 10 pages. I will only point out certain entries in that list of dates which are relevant for the purpose of the present adjudication. I would straightway invite
You are for the defendant.
I am for the defendant. Yes.
Since it is a preliminary issue regarding payment of court fees, since
I have raised that issue.
You are opening the because
yes.
And the payment of court fees disputed.
No, my lord.
Not paid.
In the meantime, we have filed an application for amendment of the plaint on the 6/17, and also we have sought for extension of the period for submission of the court fees, because if our amendment is,
I think it was earlier extended.
No, it was. There's no prayer for extension. I will satisfy your lordship that there is no prayer for extension also, and no orders to that effect have been passed. In fact, there was an undertaking on the contrary that it would be paid within that 1 month period, which expired on the 16th of April, 2024, and within that time, neither was any application for amendment made, nor was the court fee paid. And no prayer for extension has been made till date. Now, your lordship has straightway come to see item number on that.
It has not been filed prior to 16/4 or on 16/4. That's your saying.
On 17. 17 also, I will show to your lordship, it's not an application for extension of time. I will come to it shortly. Your lordship has straightway come to serial number 8 in my list of dates.
Just a second.
serial number 8, that is dated 12th March 2025. Simultaneously, my lords,
let me get it is signed by or
But today we gave today we gave a hard copy of a list of dates, man. Again,
it has not been signed earlier.
yes, my lord, it has been signed by
list of dates and events.
at page number 10. It has been signed again. The list of data.
It's a 10
Not
page.
scanned, my lord. Today, physical
Okay.
copy we have
So
given.
today obviously it is not signed.
It's a 13-page document.
ଆପଣ ପାଖରେ ଥିବ ଦେଖ ଏଠି ନାହିଁ ମାନେ ଏଇଟା ଦେଖନ୍ତୁ ଏଇଟା ମତେ ଦେଇଛନ୍ତି
That's the color version, my lord. This is the black and white one. The other one is the black and white. Your lordship can keep both.
Okay. Okay, fine. ଏଇଟା ଫେରି ଦିଅନ୍ତୁ ସେଟା ଦିଅନ୍ତୁ yes
Serial number 8. At page 2 of that document.
Yes.
Serial number 8. The date is 12th of March 2025. Simultaneously, my lords, I would also request your lordship to kindly look into the plaint, page 17.
Yes.
Your lordship has page 17?
Yes.
Kindly see para 35.
Page 17.
17, para 35 of the plaint.
It runs to how many pages?
It runs to, the plaint runs to 21 pages, and there are documents which have been annexed there too.
Okay, 35.
Sorry, my
The
lord.
plaintiff has paid a fixed court fee of INR blank.
Of INR blank, and hence the present is sufficiently stamped.
Yes.
Kindly see prayer number 1.
Yes.
Honorable Court be pleased to pass an order and decree in favor of the plaintiff and against the defendant's vessels, jointly and or severally her owner and all persons interested in her, to pay to the plaintiff 49 million US dollars, which is equivalent to 429 crores.
Yes.
Out and out, a claim for money. And your lordship knows under the rules, valorum court fee is payable. Now, here they say that they have a misrepresentation is made, that the fixed court, that the first misrepresentation is that it's a fixed court fee. Second is that it has been paid. And that thirdly, that it has been sufficiently stamped. So these are the three misrepresentations which have been made here, the first page of the in the plaint itself. Now, along with the plaint, they also file an application which is IA number, along not with the plaint, it was filed item 11.
IA number?
Serial number 11 on that list of dates.
IA number 7 of 25.
Yes.
Yes, I get that. IA number 7.
5 of plaint was presented.
Yes.
They filed this IA, and at page 5 of that IA,
Para 12.
para 11.
Para 11.
In these circumstances aforesaid, in all probability, this honorable court would not be hearing the captioned proceedings substantively, and they are likely to be stayed and or transferred to another high court. It would be manifest to compel the plaintiff to pay court fees of approximately rupees 85 lakhs in relation to a proceeding which will not be substantively heard by this honorable court. Thereafter, kindly turn to the prayer. Page 7.
Yes.
Admit the interlocutory application. 2. Pass an interim order allowing the plaintiff to pay only a not applicable court fee amounting to INR 75,000 and admit the plaint in the admiralty suit. Alternatively, the plaintiff be granted additional time and the question of payment of the remaining court fees be kept open till the transfer petition that would be filed by the plaintiff under Section 15 of the Admiralty Act 2017 is finally decided by the Honorable Supreme Court and the arbitration proceedings are concluded. Pass an order for costs and present interlocutory application. This application was filed on the 12th of March 2025. On 17th of March 2025. Now, what emanates from this is right from the very beginning, the plaintiff had no intention to pay the court fee. Now, when the matter was taken up on the 19th of March, before that, there was a stamp reporting done by your Lordship's office. And the stamp reporting pointed out that fees payable was 12 crores 86 lakhs odd. This was within the notice of the plaintiff when the matter was taken up by your Lordships on the 19th of March.
Yes.
And on 19th of March, on consideration of IA number 7 of 2025, an order was passed by your Lordships, allowing them to move the interlocutory application for arrest on that date, while granting them 4 weeks' time to pay the court fee.
Yes.
So, my Lord, my submission here to your Lordships would be that the other averments which were made in IA number 7 of 2025 are deemed to have been refused by your Lordships, because that is the principle. Because once a prayer is made and an order to that effect is passed, or on that application is passed, and those reliefs which are being sought, that await the arbitration, the transfer petition, await this and that, all those prayers were negatived by this honorable court, and this honorable court directed that within 4 weeks, court fee has to be
that IA-7 is kept pending or disposed of by that order?
Disposed.
That is disposed of.
That is disposed of. Now, your Lordship sees, on that date, the order of arrest was passed. More variation of the order before the time passes. Now, the next entry is entry number 12, 19/3/25.
Yes.
The Honorable Court passed an ex parte order directing that the defendants be arrested at Paradip Port. The relief sought in Alford, but that is the plaintiff, in IA number 7 for exemption of court fee was rejected, and the Alford's application was disposed of with a direction to furnish the deficit court fee within 4 weeks, that is, by 16th April 2025. As the stamp reporter registry of this Honorable Court, the deficit court fee payable by Alford was 12 crores 85 lakhs and odd, so and so. Now the note, neither did plaintiff make payment of the deficit court fee, nor did they file any application seeking extension of time to pay the court fee till 16th of April, that is till expiry of the period of 4 weeks. Then there is a second note. The relief sought by the plaintiff to keep the question of payment of court fee open till the transfer petition, which was then not filed by plaintiff, was finally decided by the Honorable Supreme Court and the arbitration proceeding concluded, was rejected by this Honorable Court. Then note 3. One of the submissions on which the arrest was obtained by plaintiff is recorded at para 10 of the 19th March order. The present suit is filed seeking an order and decree for a sum of 49 million US dollars along with interest, presently amounting to approximately rupees 428 crores. The plaintiff seeks to arrest defendant's vessels towards its claim for indemnifying the loss suffered on account of breach of the settlement agreements. Next, your lordship sees entry number 15, 28th March 2025. Plaintiff filed a transfer petition, that is 906 and 907 of 2025 under section 15 Act before the Honorable Supreme Court, seeking the transfer of the Gujarat proceedings and those before this Honorable Court to the Honorable Bombay High Court. In the alternative, plaintiff sought a transfer of this suit to the Honorable Gujarat High Court. Now, why this Gujarat High Court, Bombay High Court? Let me also explain that situation. Now, according to the plaintiff, there was a contract for sale of 9 ships. Now, he alleges breach of that contract. Now, for arrest of 5 ships, he moved an application, an Admiralty application in the Gujarat High Court, wherein he claimed the self-same amount of 429 crores. Self-same, exactly same amount. For 5 vessels, 429 crores. In Paradip, in Orissa, for 2 vessels, again for same, exactly same figure. He has also moved an application at Bombay under Section 9 of the Arbitration Conciliation Act for in respect of transfer of shares, which does not involve vessels. And he has also initiated arbitration at Singapore, wherein again the claim is 429 crores. Exactly same amount. So, my lords, he is forum shopping self-same amount before the Gujarat High Court, before the Odisha High Court, and also before the arbitral tribunal at Singapore. 3 forums.
And what regarding the left out 2 ships? Because for 5 Gujarat, 2 at Paradip.
They have not initiated any proceeding in respect of that.
They are now located at or floating or whatever is called? Not at Bombay.
No, one is in Amravati, the other is in Mangalore. They are on the high seas. So the claim is in respect of 9 ships, but the self-same amount is being claimed before 3 different forums. So he has sought for a transfer of this proceeding either to Bombay or to Gujarat, where the Admiralty suit is pending.
Yes.
Now kindly come to the note. The plaintiff sought, note 1.
Yes.
Plaintiff sought the transfer to weed out the possibility of inconsistent finding being rendered by different high courts on the same cause of action, and that it would eliminate the duplication of recording of evidence that would become inevitable if separate trials are held. Plaintiff's averment is inconsistent with the averment in the plaint that it will file an application for a case management stay of the maritime claim till the arbitration proceedings are heard and disposed of to address the risk of conflicting decisions.
This is to be filed where? According to the plaintiff?
This court
claimed that it will file application for case management stay.
Yes.
Meant to be filed at Supreme Court.
In this court, he has made an averment in the plaint that he will make an application for case management stay before this honorable court.
Okay.
Proceedings. That's an averment in the plaint.
Yes.
It's in para 26 of the plaint.
Yes. Yes.
Then there is a note 2. The plaintiff suppressed the fact that the plaintiff was yet to pay the deficit court fee in this suit. The transfer petition was primarily motivated by plaintiff's unwillingness to pay deficit court fee before this Honorable High Court. Alfred, by its letter dated 1st April 25 to the Registrar of the Honorable Supreme Court, misrepresented that requisite court fee has been paid in the suit to prevent the transfer petition from dismissed for non-payment of court fee. Now, Manoj, when you seek a transfer of a case, you have to submit a report that there are validly instituted proceedings before different court.
There has to be a case to be transferred.
Yes. And such a representation was made before the Supreme Court, saying that that document is also on record, stating that, yes, we have paid the requisite court fee in the Orissa proceeding. That your lordships will get at page 227 of IA number 11 of 2025.
You started at serial number?
Serial number.
I'm sorry. I'm going back to the list of dates and events.
Yes, my lord. I started at serial number 8, 9, 11,
yes, 11,
12, and now I'm at 15.
Yes.
Now, your lordships, if you I've made this statement. Now, to fortify my statement, I have to request your lordship to look into that document which they had filed before the Supreme Court. Their advocate on record had filed before the Supreme Court. That is at page 227 of IA number 11.
My lord, it's a flag H of your lordship. H for hotel.
IA 11 you are referring to?
Yes, your lordship.
Page 227.
Yes.
2 pages before annexure DD, my lord.
It's a letter written by...
That also reads 195 in the right hand.
Yes, absolutely correct. Now, this is a letter which on record, Supreme Court of the plaintiff has made to the Registrar, Supreme Court of India, with respect to the transfer petition. The diary number is given. The undersigned has filed the above-mentioned transfer petition on 28/3/25 before this Honorable Supreme Court on behalf of the petitioner in respect of the defects marked by the registry. It is submitted as under. The petitioner is seeking transfer of 2 admiralty suits that have been filed, which are presently pending before the Honorable High Court of Gujarat and the Honorable High Court of Orissa. The references to IA numbers in the transfer petition are the 2 interlocutory applications in the said suit. Therefore, once court fee has been paid in terms of the 2 suits filed, no further court fee ought to be payable on these 2 applications, which are part and parcel of the 2 suits themselves. It is requested that the matter thus be listed before the Honorable Court on my undertaking that if any further court fee is found to be payable by the Honorable Court, the same shall be deposited forthwith. And on 1st of April 2025, this representation was made.
I mean, the language is correct. It's found to be payable by the Honorable Court.
By the Supreme Court of India. Because this Honorable Court had already found on the 18th of March, before the case was
to be payable. Found by the court to be payable by the parties.
By the parties, obviously, by the parties. And the representation is that court fee has been paid.
Yes.
Now, my lords, what happens is serial number 18. On 7th of April 2025,
It in
18, 7th of April 2025, the Honorable Supreme Court dismissed the transfer petition.
Do you have a copy of that order? Can you?
Yes, my lord.
You have
Yeah,
annexed?
copy, it has been filed.
Same, my lord.
Page?
Page
229?
310. At page 300, just the page before that.
Annexure EE, my lord. Annexure EE of the same IA.
Page you are referring? 310.
310, just the page before. No, sorry, my lord. Annexure EE,
Yes,
page
310.
310.
Yes.
Quorum of Justice Datta and Manmohan.
So the Supreme Court have not referred to any regarding this aspect of payment of court fee or anything?
No, a representation was made that was accepted by the Supreme Court that court fee has been paid. And all these issues did not arise. The Supreme Court summarily rejected the application for transfer.
Yes.
Next, your lordship takes 21 at page 6, bottom.
Yes. 21 of your note.
Yes. Now, after dismissal of their application...
I'm sorry, you are referring to
serial number
21, I'm sorry.
21.
Yes.
IA number 10 of 25, which was filed by them.
Yes.
After their application for transfer was dismissed by the Supreme Court, they make an application to this Honorable Court for sale of the defendant and the terms of this or the terms that the sale proceeds thereof be deposited with the Admiralty Registrar to be credit of the present suit and be held as security for the satisfaction of plaintiff's claim in the suit.
Yes.
In para 14, they stated that the entire claim amount for seeking sale and security by stating that the applicant, that is the plaintiff, is making the present application seeking that the defendant's vessel be condemned and sold under the orders of this Honorable Court and that the sale proceeds thereof be deposited with the Admiralty Register to the credit of the present suit and be held as security for the applicant's claim in the suit.
Yes.
Now, the next day, we filed the present application for rejection of the plaint.
Yes.
The rejection of the plaint was filed on the premises A, IA number 7 was effectively rejected and disposed of by the 19th March order, and plaintiff was granted 4 weeks' time to furnish the court fee. B, plaintiff had wrongly calculated the court fee by referring to Rule 49 of the Orissa High Court Admiralty Rules 2020, read with Section 7 of the High Court Fees Act 1870, read with Schedule 1 of the Court Fees Act. C, plaintiff had paid INR 75,012, while the deficit court fee payable by plaintiff is INR 12 crores 85 lakhs odd. D, plaintiff suppressed that it was required to pay the deficit court fee before the Honorable Supreme Court in the transfer petition. E, plaintiff obtained the ex parte 19th March order of arrest of the defendant without paying the requisite court fee. These were the premises on which my present application is based.
Yes.
Now, kindly take serial number 24.
Yes.
The Honorable Court continued hearing arguments of defendant on IA number 8 of 25 seeking to vacate the 18th March order of arrest of the defendants. The Honorable Court recorded that defendant had filed IA 11 of 25 under Order 7 Rule 11 for rejection of the plaintiff's plaint in the suit. Note, during the course of argument, it was submitted on behalf of Alfred that it would pay the deficit court fee before the expiry of the 4 weeks time period granted by this court, Honorable Court.
Yes.
Now, this is important why we have included this in the note, that it is not recorded in the date. But the then senior counsel who was representing the plaintiff at that point of time had made the submission before this Honorable Court that the court fee would be paid before the 4 weeks time expired. This was on the 10th of April 2025.
Yes.
And thereafter, in fact, when the court fee was not paid within the time framed, the learned senior counsel who was representing the plaintiff refused to appear any further. And there has been a change of counsel thereafter. Now, on 16th of April 2025, time granted by this Honorable Court under the 19th March order to make the payment of deficit expired. Neither did Alfred make payment of the deficit court fee, nor did they file any application seeking extension of time to pay the court fee till 16th April 2025.
Yes.
Now, at this point in time, may I just bring to your Lordship's notice that once an application under 149 is allowed, extension can only be granted under section 148 of the CPC. May I show that to your Lordship, madams? May I firstly place 149 and then I can come back to 148.
Yes, please.
149. Power to make up deficiency of court fees. Where the whole or any part of the fee prescribed for any document by law for the time being in force relating to court fees has not been paid, the court may, in its discretion at any stage, allow a person by whom such fee is payable to pay the whole or part, as the case may be, of such court fee, and upon such payment, the document in respect of which the fee is payable shall have the same force and effect as if such fee has been paid in the first instance. So had he paid within the 4 weeks which was granted by the court, that such payment would have dated back to the date of institution of the suit.
Yes.
That is what 149 says.
Can you just a little bit digression? Can you refer to action or any provision in CPC that exempts court fee?
Yes, Order 33, that indigent person.
Indigent or by rule, I'm not saying that.
Apart from that, there is
no
absolutely no provision. Absolutely no provision. 148, Your Lordship.
Even the CP is owned by a lady. So lady are paid.
That is by special notification which have been made that certain categories of persons who are exempted, they have such power has been vested in the state, and the state can exempt. Different states have exempted.
Yes. Then you are at 148.
148.
Length of time.
Enlargement of time. (148) Where any period is fixed or granted by the court for the doing of any act prescribed or allowed by this court, the court may, in its discretion from time to time, enlarge such period, not exceeding 30 days in total, even though the period originally fixed or granted may have expired. So it was open for them to seek enlargement of time under section 148. Such an application has not seen the light of the day till date. It is not the plaintiff's case, may I also add, my lords, it is not the plaintiff's case that they are exempted for payment of court fee. It also cannot be their case that they do not have the funds to buy. Because if that be the case, the entire edifice of their claims, suit for specific performance of buying the property at 170 crores would fall. The entire edifice would collapse if they say that we don't have the money to pay. So it is not their case that we are exempted. It is also not their case we are incapable of payment. What they say, which I pointed out to your lordship, is that it would be very harsh. But that's the way the law is. You can't cater to the law to suit your convenience. Your lordship at this point in time may also see the proviso to Order 7, Rule 11.
Just a second.
Order 7, Rule 11, the proviso there.
Rejection of plaint. Proviso.
Rejection of plaint, your lordship may come to proviso, provided that. Has your lordship got that?
Yes, please. I have.
Provided that the time fixed by the court for the correction of valuation or supplying of requisite stamp paper shall not be extended unless the court, for reasons to be recorded, is satisfied plaintiff was prevented by any cause of an exceptional nature from correcting the valuation or supplying the requisite stamp papers, as the case may be, within the time fixed by the court, and that refusal to extend such time would cause grave injustice to the plaintiff.
Yes.
So even if a prayer were to be made for extension of time, which has not been made, it would have to comply with the proviso to Order 7, Rule 11
Yes.
of the CP Court.
Yes.
Now, my lords, coming back to that list of dates, serial number 24. Sorry, my lords, serial number 26.
Yes.
IA number 15 of 25.
Yes.
Now, it has been filed on the 17th of April, after the time granted for the payment of court fee has expired. The plaintiff filed IA for amendment of the plaint of the suit. Briefly, plaintiff has sought to amend the plaint to seek arrest and sale of the defendants in aid of Gujarat proceedings. Plaintiff has sought to value its amended relief at INR 20 lakhs without providing any basis for this valuation for this, and computed the court fee payable on the amended plaint at rupees 61,185. Now, this is a pure abuse of the process of law, my lords. Now you know then escape.
This valuation is of the petition for amendment or the amended suit that would be?
Plaints, they seek to amend the present plaint by bringing in this amendment.
If the amendment is to be allowed, it will be a bit nuanced. Amendment is to be allowed yet. So they are valuing it
at 20 lakhs now.
At 20 lakhs post amendment.
Post amendment. I'll show from that amendment application. They have now sought to do what? They have sought to say that the value of these two ships are 150 crores. However, I value this suit at 20 lakhs because all I want is the ships be sold, and whatever money is recovered, send it to Gujarat for adjustment in that suit. What is this? A Section 9 application.
That suit in Gujarat is filed by this particular plaintiff.
Same person.
Same person.
Same person.
As you said, for 4 ships.
Yes.
5 ships.
5 ships there.
5 ships.
Well, such a relief, in my humble submission to your lordship, would not come within the 4 corners of Admiralty jurisdiction. It does not come within any corner of any jurisdiction, my lords. Such an application is a pure abuse of the process of law. That is my submission to you.
Yes.
Now, my lords, along with this application, they file another application. That is IA number 16 of 2025.
Yes. Note 27.
Note 27.
Yes.
Plaintiff has filed IA number 16 of 2025 for modification of order dated 19th March order to seek deferment in payment of deficit court fees, not extension. Plaintiff has sought relief as below. Modification in para 4 and 9, para 4 of the 19th March order to defer payment of court fees until disposal of amendment application, and B, in the event the amendment application is rejected for the balance court fee to be paid from the sale proceeds of the defendants, or in the alternative, keep the question of payment of remaining court fee open till the review petition is finally decided by the Honorable Supreme Court and the arbitration proceedings are concluded in Singapore.
That review of the Honorable Supreme Court's order. Supreme Court's order is sought to be reviewed there.
It's sought to be reviewed. They have filed a review petition purportedly on the 17th of April. That is indicated that they have filed it. We are not aware about the contents therein. Your Lordship knows in Supreme Court a review is not listed. It will go by circulation to the judges concerned and they will decide on the fate of the review. Copy of that has also not been provided to us. But the extension which has been sought, so the enlargement of time which has been sought, the deferment of payment of court fee,
Unless that
sought
order,
on grounds.
they say that unless it is modified, on their showing that order has to be modified or recalled, whatever. That is another.
Whatever nomenclature Lordship can conceive of. Now, my lords, at this point in time, may I show to your Lordship to just compare the prayer made in IA number 7 of 25 and the prayer made in IA number 16 of 2025. Both the prayers I have given at the bottom of my, at the end of my note. Both the prayers are there. The prayer page I have.
Page 12.
11 and 12.
Yes.
Kindly see prayer number 3 in IA number 7 of 25. The third prayer. Alternatively, the plaintiff be granted additional time and the question of payment of the remaining court fees be kept open till the transfer petition that would be filed by the plaintiff under section 15 of the Admiralty jurisdiction is finally decided by the Honorable Supreme Court and the arbitration proceedings are concluded.
Yes.
And now kindly see the prayer on the next page of the present application. Number 3, the plaintiff be allowed to pay the balance court fee from the sale proceeds of the defendant vehicle. B, alternatively, the plaintiff be granted additional time and the question of payment of remaining court fees be kept open till the review petition filed by the plaintiff is finally decided by the Honorable Supreme Court and the arbitration proceedings in Singapore are concluded. Now, my lords, my humble submission to your Lordship here would be that the principles of res judicata applies to interlocutory applications also. This is the law which is settled across by the Supreme Court across all. Even the CPC, my lords, section 10 of the CPC explanation
You're looking at section 10.
Yes, my lords. Section 11, sorry, my lords. Section 11, res judicata. Explanation 5. Any relief claimed in the plaint which is not expressly granted by the decree shall, for the purpose of this section, be deemed to have been refused. And there are many judgments which say that this principles apply to interlocutory applications also. And
Yes.
And 141, reading with the section 141, which says the procedure provided in the court in regard to suits shall be followed as far as it can be made applicable in all proceedings in any court of civil jurisdiction. So, my lords, this prayer, which is now sought to be made in the applications which are also before your lordship, to be adjudicated upon. My humble submission to your lordships would be their abuse of the process of law, untenable in law, is not worth the paper on which they have been.
Yes.
Now, your lordship takes entry number 28.
Yes.
The plaintiff files a review petition before the Honorable Supreme Court in respect of the decision dismissing the transfer petition. They made the prayer earlier on 17th, on the same day, they also might make an application before the Supreme Court for seeking review.
Yes.
Now, on 17/4, this Honorable Court passed an order directing that IA number 8 of 2025, along 8 of 2025 is an application filed by me for vacating the interim order. Along with the amendment application, that is IA number 15 of 2025, and the court fees deferment application, IA number 16 of 2025, be listed for hearing on the 21st April at 10:30 a.m. Note, plaintiff sought an amendment on the ground that the court fee deferment application has been filed for extension of time to comply with the 19th March order. The amendment application has also been filed, the same were not listed and ought to be considered. Kindly see that order, my lord, 17/4 order, where it is recorded that a submission was made before this Honorable Court that an application for extension of time has been filed. That your lordships will find at para 5 of the order.
Yes.
Para 5, third line. Plaintiff submitted that for extension of time to comply with the order of the Honorable of this court dated 19/3/25, passed in IA number 17 of 7 of 2025, an interlocutory application, that is IA number 16 of 2025, has been filed, it should be. Another IA has also been filed for seeking to amend the plaint. Now, your lordship has seen IA number 16 of 2025. It is not an application for extension of time.
IA 16 prayer is not for extension of time.
Not for extension of time. So that was another misrepresentation in my humble submission before this Honorable Court. But for the submission, maybe the order of arrest would not have been continued on that date.
Yes.
Now kindly come to serial number 30.
Yes.
Objections on 21st of April 25, objections were served upon the plaintiff on behalf of the defendants to the amendment application, praying for dismissal briefly on the grounds that amendment application is an attempt to evade payment of court fees. Plaintiff has sought to incorrectly and baselessly value the reliefs in the suit at 20 lakhs after the time period granted by the Honorable Court to make the payment of deficit court fee under the 19th March order expired on the 16th of April 25.
Yes.
B. The amendment application alters the nature and character of the suit by converting its original claim in the suit of a purported maritime claim before this honorable court to a collateral proceeding in aid of the Gujarat proceeding without any adjudication on merits in this honorable court. C. Amendment application does not disclose any subsequent event or incident. Plaintiff has commenced the Gujarat proceedings before the suit was filed before this honorable court after obtaining the ex parte arrest of the defendants under 19th March order by making substantive claims with this honorable court. Plaintiff seeks to shift its nature of claim to in aid of Gujarat proceedings. D. Alfred cannot seek arrest and sale of defendant before this honorable court to satisfy a claim pending in the Gujarat High Court. Plaintiff seeks to amend the plaint to seek arrest, sale of the defendant and appropriation of sale proceeds in aid of its claim before the Gujarat High Court and essentially abandon its so-called maritime claim before this honorable court on merits is legally impermissible. The suit itself, the edifice of the suit collapses. If it is no longer a maritime claim, this maritime suit cannot survive. And this is definitely not a Section 9 proceeding under the Arbitration Conciliation Act. E. Plaintiff's case is based on contradictory valuations. The plaintiff manipulates vessels' valuations, inflating them to assert its claim value and deflating them to justify more assets on the ground that the sale price may be lower due to prevailing market conditions, vessel condition, and other commercial factors. This undermines its and reflects mala fide. This is where, my lords, I attribute mala fide to the plaintiff. Note, plaintiff amendment application is mala fide, is not necessitated for the final adjudication of the issue in the suit and does not disclose any subsequent event. And in such circumstances, going by the standards set forth by your lordship and the Honorable Apex Court, while dealing with applications for amendment, such an application for amendment will not stand the test of law. Then serial number 31. 21-425, objections were served upon the plaintiff on behalf of the defendants to the court fee deferment application, praying for its dismissal briefly on the ground that A, there exists no validly instituted suit in the eye of law, since plaintiff failed to pay the deficit court fee of INR so-and-so by 16th April 2025, that is before the expiry of the 4-week period granted this honorable court by the 19th March order, no validly instituted suit exists by operation of law. B, plaintiff has sought to undervalue its claim to evade payment of court fee. Plaintiff has mischaracterized reliefs of arrest and sale of the defendants as declaratory and consequential reliefs in aid of its claim in Gujarat proceedings. Despite this, plaintiff continues to seek security for approximately its claim of $49 million US. Plaintiff has sought to undervalue its suit to an arbitrary rupees 20 lakhs in view of the amendment application and incorrectly claimed that the court fee payable is 61,000 odd to even deficit court fee of 12 crores odd. Reliefs in the court fee deferment application are incapable of being granted. Reliefs of indefinite deferment of payment of court fees till the plaintiff's review petition was decided and the arbitration proceedings are concluded cannot be granted since 1. Nearly similar reliefs as claimed in IS 7 of 25 have already been rejected by the 19th March order. 2. Substantive modification of the 19th March order cannot be sought in the guise of interlocutory applications. 3. Court fee cannot be paid from sale of the defendant's assets. Then D. Application is vexatious and constitutes an abuse of the process of the court. Plaintiff's malified conduct of 1. Filing the suit without paying the full requisite court fee. 2. Obtaining an ex parte arrest of the defendant. 3. Seeking a paid deficit court fee. 4. Filing the transfer petition with a view to avoid paying ad valorem court fee. 5. Not paying the deficit court fee within the 4 weeks period. And 6. Filing the amendment application to change the nature of the suit to evade payment of court fees after expiry of the 4 weeks period disentitles plaintiff from seeking any of the reliefs. E. Application has been filed after expiry of 4 weeks period time court to furnish deficit court fee. Plaintiff filed the court fee amendment application after expiry of the 4 weeks period granted by the Honorable Court on 19th March order. Therefore, it cannot be considered. F. Application is for modification of the 19th March order and not for extension to pay deficit court fee as submitted at the hearing on 17th April 2025. At the hearing on 17th April, plaintiff had the matter adjourned to have the application for extension of time to comply with the 19th March order considered. Plaintiff does not seek to comply therewith, but seeks a modification of the 19th March order to defer payment of court fees despite nearly identical reliefs having been rejected by this Honorable Court. So, my lords, to conclude, my lords, usually your lordships grant an interim order once a properly instituted suit is in place. And a properly instituted suit includes payment of requisite. Now, your lordships have exercised a jurisdiction or a discretion which is vested in your lordships by law under section 149 of the CB Code to grant an extraordinary relief to the plaintiff and which causes a grave prejudice to the defendant by arresting his vessel. And your lordship has subsequently seen the level of misrepresentation, the level of abuse of the process of law, which has been exercised by the plaintiff subsequent thereto, to firstly evade payment of court fee, and then take a stand that court fee, we will not pay the court fee. And if at all we pay, we'll sell your assets and then pay the court fee. Or we'll get an award and then pay the court fee. Such a thing is untenable, unrecognizable in law, and such a prayer on the face of it is an abuse of the process of law. And my lords, just one situation your lordship may contemplate. On 19th of March, a restraint order has been passed to my prejudice. Now, if the plaintiff were to abandon the suit today and run away, my loss would be incalculable. Kindly look at the loss the state exchequer would suffer. ₹12.86 crores due to the state exchequer is being sought to be defeated in this clandestine manner, in a most unscrupulous manner. Now, my lords, whatever I have submitted, to back it up, I have case. Maybe if necessary, I will take them in rejoinder after my learned friend finishes. Otherwise, you may hear.
So, one question from the court. One question from the court
regarding
this amendment of the plaints, amendment of the plaint and the pleadings, in the context of amendment of the valuation, is there any provision in CPC which permits that?
My lords,
I'll explain that also with judgments. I mean, I was anticipating because, and whether because the thing is that, because again I'll repeat my question I had already asked, that whether prior to amendment the court can go into that aspect.
my lords, kindly
I mean,
see.
it can be, because if you see that if it is dismissed, then it is open for the plaintiff to file it again.
Yes.
That consequence of non-payment.
And seek rearrest of the vessel also.
Yes.
That is also there. Now, my lords, kindly see application for a while.
That is IA number?
IA number 15 of 25.
Yes.
Kindly take para 10.
Yes.
The value of the defendant's vessel, which are located within the jurisdiction of this honorable court, is as follows: 153 crores.
Yes.
Now, on the face of that, kindly now come to para page. Sorry, my lord. Prayer. It begins at para 18. This application has not been paginated. Para 18, invite your lordship's attention.
The pending, that pending the hearing.
Yes, that pending the hearing and final disposal of the suit, this honorable court be pleased to issue a direction for conducting the sale of defendant's vessel by public auction, advertised in the public notices column of the Indian Express and one local newspaper, or commanding in large circulation in Cuttack prior to the date fixed for the sale.
This sale, quote unquote, is in the context of execution or context of payment of court fee?
In the jurisdiction, such a power is available.
That
for security, basically.
Such a power is available that the arrested vessel can be sold for the purpose of security. Such a provision is there, but kindly see the conduct.
I mean, that jurisdiction has been sought for in the plaint, but it was not in the original plaint.
No, it was brought in by way of that application, which I pointed out from my list of dates.
Okay. Yes.
That is by way of IA number 10, which was filed, my lords.
That is serial number?
At serial number 21. Serial number 21. It was filed on the 8th of April.
Yes. Which particular provision gives this power in this Admiralty jurisdiction?
Sorry, my lords?
In which particular section or rules gives this power in this 2017 Act?
16. Rule 16.
Section 16 or Rule 16?
Rule 16.
Rule 16 of the High Court rules?
Yes. Application for sale of arrested property.
Lord, we just handed over.
Yes.
Mr. Padi had just handed over.
Yes, please.
In a suit in rem, if the property proceeded against has been arrested, the plaintiff may at any time alter service of after service of the writ of summons upon the defendant, or after the defendant.
That should read after, not alter.
Yes, after the defendant's appearance, whichever is earlier, apply to the court by notice of motion for an order that the arrested property be sold by the marshal and the sale proceeds be paid into the registry. The court may make such orders on the claim as it thinks fit. Now, kindly, having read this rule, kindly see the prayer in the application. IA number 10 of 2025. Your Lordship will get that in my list of dates only.
The suit in rem is defined in the definition.
Sorry, my lord?
Suit in rem.
Suit in rem, yes. This is a suit in rem. It's recorded in the order of 19th March also. This is a suit in rem.
Yes.
2C of the rules.
Yes. But even if it is against a particular property or particular SIP, it is a suit in rem.
Suit in rem.
Yes.
Now, kindly come back to serial number 21 of my list of dates.
Yes, 21.
Plaintiff filed IA number 10 of 2025 for sale of the defendants on the. Has the lordship got that?
Yes, 21. IA 10 of 2025.
25.
I'm right there.
Plaintiff files IA number 10 of 2025 for defendants on the terms that the sale proceeds thereof be deposited with the Admiralty Register to the credit of the present suit and be held as security for the satisfaction of the plaintiff's claim in the suit.
Right.
Now what they say is sell the vessel. In IA number 16, they say sell the vessel for the satisfaction of the decree which I may get in Gujarat. And after that, irrespective of whatever powers may be there in law.
Maybe this is your answer to that query, that whether it is in nature of execution or it is a kind of a, not exactly execution, but a prospective, result of a suit that is pending
before
in
judgment.
in
An
Gujarat.
attachment before judgment.
Yes.
So, my lord,
let it be sold, then the proceeds be attached.
Proceeds be attached for satisfaction of my decree.
That may happen in Gujarat.
In a suit which is not within your jurisdiction.
Exactly.
In a suit which is outside your jurisdiction.
Yes.
And that money be transmitted from Odisha to the registry of the Admiralty Register in Gujarat.
Yes.
That is the prayer. Now, my lords, what my submission to your lordship is that whatever may be available in law can be exercised by a party. But that cannot tantamount to the abuse of the process of law. And here is a case where whether such powers are available, whether such reliefs are available to be taken in law or not, is not my point. My point is that you are abusing the process of law to alter your position from time to time, changing the nature and character of the suit, litigation, the list that you had presented before the court at the first instance, to the grave prejudice of the defendant and huge loss of money to the state. I will rest my arguments for the time being. If I have anything else to say, I will come back and rejoin.
What I can specific reply, because I think my friend Mr. Mukherjee has covered both applications, Order 7 Rule 11 as well as the amendment.
This microphone is switched on.
Yes, my lord.
Yes. The speaker, you have to raise the height for your height.
I'm sorry, my lord.
Yes.
But I hope I'm audible to you.
Yes, yes.
Before that, my lord, I'll just take to the legal provision of Section 4 of the Admiralty Act.
You are relying on any notes or?
I have not prepared. I'll file that. Maybe by tomorrow I'll file it. Because my date chart itself will be the cause of action or the background that I'll be explaining before your lordships.
You are referring to
Section 4 of the Admiralty Act 2017.
Yes, Act 2017.
Yes. The first thing has to be seen whether my claim is a maritime claim or not.
Yes.
Because whatever has been said and has been described on my conduct, my way of...
And Mr. Nanda also agree that IA has to be taken up. In this scenario, the IA what has been the amendment and this
subject to that, then the Order 7 Rule 11.
Yes.
So if your lordships would seek Section 4.
Yes.
The High Court may exercise jurisdiction to hear and determine any question on a maritime claim against any vessel arising out of any. Your lordships may straight away come down to R. Out of a contract for the sale of the vessel.
So you're referring to 4R.
1R.
Okay. Dispute arising out of a contract for sale of the vessel.
Sale
Yes.
of the vessel.
Yes.
Now the question is, claim means whether if I go by my learned friend's arguments, the claim has to be only monetary, not otherwise. Because if I seek an injunctive relief, whether that can be deemed as a claim as a maritime claim or not. For a declaratory relief, whether it can be treated or not, that I'll lordships also. The next is section 5. Why the requirement of filing before different high courts? And why my amendment application, that will form the background also. Then I'll come to the, my lord, the documents. Arrest of vessel in rain. Your lordships got that?
Yes.
Section 5. The High Court may order arrest of any vessel which is within its jurisdiction.
Yes.
For the purpose of providing security against a maritime claim which is the subject matter of an Admiralty proceeding. It doesn't say before the same court, but it goes on, where the court has reason to believe that the person who owned the vessel at the time when the maritime claim arose is liable for the claim and is the owner of the vessel when the arrest is effected. Or the demise character of the vessel at the time when the maritime claim arose is liable to be for the claim and its demise character or the owner of the vessel when the arrest is effected. Or the claim is mortgage or a charge on the similar nature of the vessel, or the claim relates to ownership or possession of the vessel, or the claim is against the owner, demise, character, manager or operator of the vessel and is secured by a maritime lien as provided in section 9. The High Court may also order arrest of any other vessel for the purpose of providing security against a maritime claim in lieu of the vessel against which a maritime claim has been made under the Act, subject to the provisions of subsection 1, provided that no vessel shall be arrested under subsection 1.
Kindly reread 2.
Yes.
The High Court may also
order arrest of any other vehicle.
Vessel for the...
Vessel, sorry, I'm so sorry, my lord. Vessel for the purpose of providing security against a maritime claim in lieu of the vessel against which a maritime claim has been made under this Act, subject to the provisions of subsection 1.
Yes.
So the question here is, even if the claim may be at a different place, whether, my lord, this honorable court can...
You mean to expand this maritime claim against a maritime claim is
instituted in a different
anywhere.
High Court also.
So what about that particular court?
That is why,
which is trying that particular.
That is why, my lord, because the
I'm not interjecting exactly. I'm just discussing in the sense because if
agreement
by interpreting this way, suppose the claim is at Gujarat, it's a maritime claim. The vessel is at Paradip or here whatever court in Odisha, any court in Odisha. So whether it is the Gujarat High Court dealing with the maritime claim or the Odisha High Court only dealing with the arrest.
My lord, I'll just explain, my lord, why it is so. The agreement was for 9 vessels. So when they did not honor the agreement, I'll come to that, how it happened and everything. So we filed before the Gujarat High Court on 11th of March. Because prior to that, there were certain acts by them where they were creating charges in favor of third party regarding the properties which were involved in the agreement. And there's a Section 9 order from the Bombay High Court also in our favor, where their character has been narrated in detail. So I'll come to that. So what happened is on 11th we filed because 5 vessels were under the jurisdiction, territorial jurisdiction of the Gujarat High Court. 2 were before this Hon'Ble. Now the entire claim amount, the same 428 crores or 429 crores, was also the claim before the Gujarat High Court, which was said here. That is why the amendment, I said I relinquished that part because that is already a subject matter there. But to satisfy that claim and the 9 vessels, whether they will satisfy or not.
Mr. Nanda, actually, in fact, that's the question. Suppose you abandon your prayer here for this maritime claim. Can you confine your prayer only for arrest? But because if you are by taking a cue from your submission, you can do that. Do it at Gujarat also.
Because the vessels are not in the jurisdiction of the Gujarat High Court.
Because it says maritime claim.
I can claim it. It is the suitor's choice.
So according to you, which particular section?
It is the suitor's choice where I can or where I cannot.
Yes, definitely.
So if the suit property is or the vessel which is the subject matter of the agreement or the sale agreement.
No, you are. I mean, to that extent, you agree with Mr. Mukherjee that you want to satisfy the Gujarat courts?
Yes, because it is a single agreement and a single claim. There cannot be multiple claims arising out of a single agreement. There may be nature of claim may be different.
Because also you have filed petition in Supreme Court for transfer of this suit to Gujarat.
Which has been dismissed and a review
Which has been dismissed.
And a review application has been filed. Take away the jurisdiction of this Hon'Ble.
No, it's not a question of taking away the jurisdiction. It's not a question of taking away the jurisdiction.
Issue is whether if the claim is before one High Court, can I, that's why my lord, when I first said whether I can file for an injunctive relief and a declaratory relief here to arrest, and then as per the Admiralty Act, whether the other other permitted
claim is fine. Claim is fine that you are claiming the same 428 crores at Odisha, at Gujarat, at Bombay, and at Singapore in arbitration.
No, not at Bombay. Bombay is different.
Anyway, sorry, not Bombay, at Singapore also. But regarding the ship, you are having 5. The claim is regarding 5 at Gujarat, 2 at Odisha, 2 here,
and 1 vessel is in Gujarat, and here 2 vessels have been arrested.
Yes.
So now, my lord, I'll just take your lordships just to the background so that your lordships gets it why the issue arose. If your lordships would come to in the plaint.
No, unless Mr. Nanda.
Yes.
I have to deal with this extension petition and non-deposit of.
No, my lord, extension petition I'll my lord come later on. Because that I'll also reply.
No, because that order is binding.
Yes.
After it has been passed and that is not yet to be
disposed of.
Disposed of, so that
it is binding. I'll explain, my lord, how can the extension be granted or not.
You go at your own way of approaching the matter. That's not an issue.
No, because the 2 issues might have a conflict, so that is why I want to segregate.
Not exactly a conflict. It's kind of a sequence.
Sequential.
Because when you on your own showing that you say that you have not paid.
No, we have not.
Now you say that though
if my amendment is allowed, then I may not be required to pay also. That is where their objection is.
No, you have not taken that plea in as far as the extension is concerned.
No, extension is because extension is subject to this amendment.
You filed. If you look at your prayer in the plaint.
May I just one line?
Yes.
Amendment of what? Amendment of a plaint which is in existence.
Yes.
Is there a plaint in existence today? Till that time is not extended.
I think that has already been debated.
Firstly, the time will have to be extended, if at all, and then only a suit comes into being. There is no suit in existence. And that is why, my lords, that application for extension has to be heard. Modification.
If your lordship should see the prayer in my application.
Plaint.
My lord, no, in the prayer in my IA 16 of 25.
Yes, IA 16.
My lord, second prayer. Order dated 19th March 2025. That is at internal page 8 of that IA, if your lordship.
No, then this technical issue that whether this bench can, when the other bench is available, can modify that.
That, my lord,
No, you have to assist me. Both of you must assist me.
It should not be normally in the normal course as per the the court practice is concerned, but so far
And
as
more so in a suit. When it is
In a
not
suit.
kind of a
it is not a writ petition.
writ
it is in
petition
matter
where
of suit.
this assignment changes and yes, Mr. Mukherjee. Both of you assist because
The point here is this, my lord. It is a question, since it's a suit, it's an admiralty jurisdiction. Let us assume of a situation in a suit. Cuttack principal civil judge passes an order. He goes off to Bhubaneswar and another person comes in. It's not that the modification will have to be dealt with at Bhubaneswar now. It has to be dealt with by whoever is in session of the administrative jurisdiction of this High Court. So it will have to be done by your lordship. As long as the administrative jurisdiction is vested in your lordship, it has to be done here. It cannot go to any other.
I have no objection also.
No. It's not. It's a question of seeking your assistance also. You agree with that submission
Regarding, my lord?
because Mr. Mukherjee's submission is that since the court remains the same.
No,
that's
I
the
have
submission.
no objection.
No, I
to
don't
this
know.
bench.
The problem is that this complexity will arise again. The way this suit has proceeded.
No, then, my lord.
So one
then
of
we
the
have to
grounds of
refer to
challenge,
the-
subsequent issue is that whether this subsequent court had jurisdiction.
My lord, then, my lord.
Because the other
like-
difficulty is that it's a IA. It's not
IA.
that it's a IA seeking modification of the earlier.
my lord, then
order.
maybe we have to refer to the High Court rules. I don't know what it
So
says about it.
you can.
But if we go by the purely terms of the assignment of the subject matter,
Mr. Mukherjee's
then-
submission is that.
and I subscribe to that, I have absolutely no objection to that also.
But usually the High Court rules is that even if there is a change of assignment, if
If
the
it is
order is
for
sought to be modified or
modification-
recalled,
Yes.
it shall go to the same bench if it is available. I don't know what exactly will be the implication. Even appeals, Mr. Mukherjee, appeals also it goes to the same bench which
It
passed the
has-
order.
Because these are special jurisdiction which are vested by the High Court rules. Original jurisdiction. Like company matters. It is vested, the roster of the Chief Justice fixes it. The administrative jurisdiction, even if your lordship were to say that this matter has to go before that bench is not equipped to hear the matter because it does not have the jurisdiction.
No, that exactly happens in case of roster assignments.
Yes.
Even if the bench is not available, it goes to the Honorable the Chief Justice in the administrative side. He refers it because I cannot refer. That there you are absolutely right. I cannot refer to the other bench, but since the other bench is available, so what would be the
Other
consequence?
bench is not available. Administrative bench is only one here. There is no other bench in the High Court today. This matter cannot by default go to any other court. That is because your lordship has been assigned with administrative jurisdiction.
No, one thing, Mr. Nanda, you consider this because then I'll record that both of your submission that.
No, I cannot, my lord. I'll never have that objection, at least so far.
No, you are not objecting.
Otherwise also.
I mean,
Otherwise also.
In fact, he is not objecting there also because I am seeking his assistance that whether because every change of roster, whenever there is a order passed by a bench that is available, it goes to that bench, irrespective of the roster. But the distinction is that it's not a roster, it's a jurisdiction
It's a
of
jurisdiction.
the special statute. So there lies the difference. It is like even appeals also. Even
Yes.
appeals and criminal appeals or even writ petitions. Writ petition is common that it goes to the same bench. By assignment by the Honorable the Chief Justice. In case of retirement or transfer of the Honorable Judge, at least one member should be there. Then the bench with the roster. So you can address me. You consider this and address me after recess on this point. And you
extent, my lord, I also say that
no. Please be sure that it will not add to the further complication of as far as because this is the way this is being progressive. Please address and you consider what I think Mr. Mukherjee has a point that.
I have also subscribed to the same view.
High Court rule overwhelmingly says that it should go to the bench available.
No, but because of the special nature of and character of these kind of
and
assignments,
irrespective of the roster of the bench, it goes to the other bench. This is not to be taken here. So please carry on. Yes, the prayer.
So that is for the modification of the order dated so and so to the extent of paragraph 4 to defer the payment of court fee until the disposal of the amendment application, that is IA number 15 of 2025. So now, my lord, to that extent, what is the prayer sought for in the amendment application, or what is the amendment that is sought for, my lords? That is
to kindly see the order of you start with that particular order. Just again
19.3 order.
Yes.
19.3 order.
What was the prayer and what was the this 19th March was passed in IA number?
My lord, IA number 6.
IA number 6.
There is para 6, it starts. The first.
Admiralty is read with IA number 6. Yes.
IA number 7, my lord. First.
Yes.
Matters taken up so and so the interlocutory application filed by the plaintiff seeking extension of time to pay the deficit court fee. Heard Mr. Parija, learned senior counsel, being assisted by so and so. Considering the averments made in this interlocutory application and also the submission advanced on behalf of the plaintiff, the deficit court be furnished within 4 weeks. The registry shall report with regard to its filing and sufficiency before the next date. So now, my lord, and accordingly, the IA was disposed of. I filed the application for seeking that, my lord, relief, which I read out before lordships in 15. Lord, that was on 17th of
No, they
April.
can continue reading that IA number 6 of 2025.
All right.
Because you are seeking change, modification of this order.
Yes.
In IA number 6.
IA number 6.
So please kindly continue that order, reading from para 6.
The present Admiralty suit has been filed. Basically, the order is regarding the time period granted to me, because that is in IA 7. The IA 6 is the arrest order. So the requirement of the of that period which has been granted.
Yes, kindly start reading with paragraph 7.6.
All right.
Or whichever you prefer from the paragraph 7, it's up to you.
No.
I was just suggesting that to court it, sir.
If you're not sure, just one paragraph before
please,
that,
please.
7.5.
Yes.
Between October 24 and February 25, Samson and Underwater made several executes and kept delaying the execution of the agreements.
Several excuses. Several executes or excuses?
No, my lords. Delaying the execution of these aforesaid agreements.
Samson and Underwater made several executes or several excuses? Excuses, yes. And kept delaying the execution.
The execution of these aforesaid agreements. Even though all material terms and conditions of these agreements were agreed and finalized, and the agreements were even symbolically executed between the parties, on several occasions, Samson and Underwater confirmed that the creditors were apprised of the deal and they were about to formally execute inter alia the memorandum of agreements. However, till date, Samsung have not formally executed the MOAs. Accordingly, they are in breach of the clause 3.1 of the settlement agreement and are liable to indemnify the plaintiff for its loss in terms of clause 3.3 of the settlement agreement, including for loss of revenue and profit. The plaintiff has quantified its losses as the difference between the current market price and of the 9 vessels and the intended distress sale price at which the plaintiff would have purchased the vessels from Samson and Underwater. Mr. Senior Counsel submitted that the present maritime claim arises under Section 4(1)(r) of the Admiralty Act and constitutes a claim arising out of a contract for sale of the vessel. He further submitted that a claim for indemnity would also constitute a maritime claim, since the underlying claim is towards a dispute arising out of a contract for the sale of vessel. Then, my lord, the text. Mr. Procedural and Senior Counsel further submitted that the plaintiff has invoked arbitration by notice that so as amended on so and so date. However, the present Admiralty suit is against the defendant vessels, which constitutes a claim in rem. It is submitted that the existence of an arbitration clause in the settlement agreement or any proceedings in arbitration would not come in the way of present suit, since this is a claim against the vessels in rem. A perusal of the settlement agreements makes it apparent that clause 3.1 stipulates that owners of the defendant vessels are required to sell the vessels in question and formally execute memorandum of agreements within 30 days from the date of settlement agreement. No such memorandum of agreements as alleged have been executed for the purchase of vessels stipulated in the settlement agreements. Clause 3.3 of the agreement stipulates that owners of the vessel shall be liable to indemnify the plaintiff herein for any losses incurred or arising out of a failure or breach of clause 3.1 of the agreement. The present suit is filed seeking an order and decree for a sum of USD 49 million along with interest, presently amounting to approximately 428 crores. The plaintiff seeks to arrest the defendant vessels towards its claim for indemnifying the loss suffered on account of breach of settlement agreements. It is stated that both the defendant's vessels are presently situated at Port of Paradip, Orissa. The plaintiff has furnished prima facie proof of the location of these vessels. It is therefore apparent that the defendant vessels are within the jurisdiction of the court, and accordingly the plaintiff has approached this court on an urgent basis seeking arrest of the said vessels. Heard learned counsel for the plaintiff perused the documents annexed to the suit. This court is prima facie satisfied that the claim is maintainable in this forum of Admiralty against the aforesaid defendant vessels. That is so and so the vessels' names. Unless the said two vessels are arrested, irreparable damage may ensue. Thereby, this court is persuaded that the balance of convenience tilts in favor of it. Considering the submissions and the averments made in the suit, coupled with the documents enclosed to the suit, this court feels a prima facie case is made out against the defendant vessels. This court is therefore of the considered opinion that unless order of arrest of defendant vessel so and so is passed, relief claimed in the suit would be rendered infructuous. Ordered accordingly. Hence, the defendant's vessel so and so be arrested at Paradip within the Indian territorial waters by the port officer and customs authorities or any other competent authority and keep the vessels under arrest until further court. Accordingly, the plaintiff is at liberty to communicate the order so and so, my lords. Then 15, issue notice. Then clear that it will be open for the para 16. It is made clear that it will be open for the defendant's vessels to approach this court even prior to the returnable date with adequate notice to the plaintiff. Now, my lord, just for a moment, before I go to the settlement agreement,
So your contention is that even if the court fee was deficit as per suit instituted due to lack of court fee, in view of IA number 7, by extending the period by 4 weeks, the order could have been passed in IA number 6, and that has been passed.
That has been passed. Okay. And whether
Mr. Mukherjee, what is your submission? Because yes, I understand you were set expert. I mean, then you were not heard. It was ad interim ex parte injunction.
Correct.
So, what would be your response to that? Short response.
My lord, my short response is this, my lord. The arrest order was passed on the basis of a claim of 428 crores. Now they are removing that claim. So, what is the consideration for the arrest?
And regarding regarding that IA number 7, extending the time, and IA 6 exercising the arrest power, it was a correct exercise also.
My lord, subject to fulfilling the conditions as stipulated by the court, that was a jurisdiction vested in the court. I cannot question that.
No, I understand, but it is not mentioned in the order in IA 6. That subject to fulfilling of depositing of the court fee.
No, it is there, very much there.
It is there.
Para 4, kindly see 19.3, IA number 7 of 25.
Yes. I'm looking at that. But which paragraph in the...
Para 4. Kindly see para 4.
Para 4 I have read.
Para 4 of IA 7.
Para 4 of IA 7.
IA 7 of 25.
I'm looking for that in IA 6 actually.
No, it's there in 7. Because only after entertaining the IA 7, court goes to 6.
Absolutely.
Because in the absence of 7, 6 could not have been.
Absolutely. But the arrest is subject to payment of court fees. That I was searching in IA number 6.
No, it is there in 7. So, my lord, it's a part of the same order, my lords, ultimately. Kindly see in para 4. Considering the averments made in the interlocutory application and also the submission advanced by the plaintiff, the deficit court fee will be furnished within 4 weeks. The registry shall report regard to the filing.
Furnished. It doesn't say will be furnished. Will be
the registry will report with regard to its filing and sufficiency before the next date.
Yes.
So, but it's only after fixing the modalities, the court goes into the merits. Had it not been for para 4...
Mr. Nanda also, please respond to this. Even if it is not mentioned in IA number 6, is it correct not to mention in IA number 6, or it is understood that IA number 7 has...
No, my lord, that stands
correct.
And it doesn't say that it's not that a peremptory order or something where it says unless it is deposited.
Usually in defective suits, that is the order.
But here it has not been passed.
And the paragraphs, as Mr. Mukherjee has correctly pointed out, the paragraphs are in continuation. In fact, it's part of the same order. Yes.
So, my lord, before I go to the other part of it, I'll just take a lordship to the order passed by the Bombay High Court in the application made on section 9 by me.
It is not part of the record.
That order is not there.
This regarding this operative portions of this particular order, like 14 and 15. So you are providing, both of you agree and provide a draft order, or how this typical language is used?
I'm not able to get
the intimating the marshal, all these things, because this is very typical to this kind of jurisdiction.
Yes.
So any assistance you have to render. So that was my... Yes, you have provided a copy. Yes. What turns out of this order? Turns on this order particularly?
Not the conduct of the party, why the arrest became imminent, or why our doubts that the clandestine transactions entered into by the defendants, where is how we came immediately before both the high courts. It's not that it was out of that the wish that we'll go to separate high courts, but it became imminent. Because what was there prior to that? I'll come to the agreement terms, but before that, my lord, this order, because since this has been an order, so it is already on record. Or at least my friend is aware of it. Oh, I'm sorry, my lord. It is there, part of the, on record itself. My friend says that is in reply to the IA number 8 of 2025 filed by them.
That is annexer?
D1, page 93.
All interjection, Maharaj. If your lordship is hearing this on merits, then there is an application for vacation of stay which I had filed, which was being heard.
No, there
now
I may again clarify that I am hearing the IA.
IA. So that is only for purpose of court fees.
For that
purpose of court fee.
Because now after that IA 6 and IA 7.
Yes.
This court, I mean this continuing this admiralty jurisdiction has to that effect of 6 and 7.
Yes. So Maharaj, if that be the case, then
no, I mean let him be satisfied. Let him be satisfied with whatever way he wants to present the case.
Then, my lord, I'll just give a one reply to my learned friend. When an order 7 rule 11,
we can continue after recess because it is not going to be completed within 5 minutes.
Will do.
Any mentions? This is at page 93. You are saying in that.
I'll come back to that in the reply annexure D by 1. I'll come back to that. Before that, my lord, certain other issues that is.
Yes, any mentions?
Out by my friend.
Yes.
My lord, item number 3, my lord.
Yes, 3.
My lord, I am for the petitioner, my lord.
No, you want the matter to be taken up?
No, my lord, because the AD nod has been received.
No, order has to be passed. You see, whenever there is a AD not returned as a judicial order, it has to be recorded and further order has to be passed.
My lord.
So I am not taking up any matter out of turn. Any adjournments or anything, these leftover matters because this particular suit has been in the list for last 2 weeks almost, 1 week. So that is how it has reached. So all this, whatever is after notice matters, it will be listed tomorrow. Or day after. If you want any adjournment, any date, then you suggest.
My lord, next week, madam.
You want next week?
My lord.
No, because even if you are not, your name is?
Abhijit Mahanti, my lord.
You see, next week the report may not come.
No, my lord.
So please appreciate that. Suppose somebody has appeared, I have to see whether it is sufficient. I have to see whether the postal tracking report, so what it shows.
My lord.
At times there are mistake in reporting by the registry. Insufficient is made sufficient.
Let it taken up then tomorrow, day after tomorrow.
So let it be in the list. Because
my lord.
It is possible that adverse order will be passed.
My lord.
Yes. Let it be in the list. So let us leave it there. Any other adjournment or any date, anyone?
24 A1, both parties are there, my lord. He has to produce the records. Any other day.
Yeah, agree for a date. 24. Mr. Malik is there.
Yes, I am there.
Mr. For union.
For union, Mr. Pradhan.
Sorry? Mr. Mahendra Kumar Pradhan, you are there. CGC.
Senior panel counsel.
Senior panel counsel. 21, sir. कह दियो तू जल्दी.
केबे प्रोड्यूस करेंगे
Next week.
नेक्स्ट वेडनेसडे
पूरे डेट कर देबे 9/5.
My lords, item 11, my lords.
11.
I am for the petitioner.
Yes.
My lords, I pray for adjournment after vacation, my lords.
It's a fresh matter.
My lords.
You don't want a notice to be issued.
Notice to be issued.
But you have to wait the matter to reach actually. I can't have done, then why I'll refuse others, whoever is mentioning.
My lords.
So why do you want after vacation a fresh matter?
My lords.
You don't want to do the matter now, what? I
no, my lords,
follow you.
I will, my lords, I will.
Listed, I mean, listed ରହିବ ନା ରହିବନି ଚାହୁଁଛନ୍ତି ଆପଣ?
Listed ଥାଉ.
Listed ରହିବ ତ ଠିକ ଅଛି, it will be. No matter is going to be taken out of list. Unless wanted or, agreed by the learned counsel.
My lord.
Yes.
Item 4. There is a noting in orders leftover matter. There is a noting that neither AD nor unserved.
So those matters I have to pass orders. Directing the registry to verify the appearance, or I have to see myself whether there is a proper or not. So that So since it is a order, it is, though it is after notice, but it is in the nature of orders.
Yes.
So you can wait for tomorrow, it will be reaching
Tomorrow.
or day after, or by that way. So it is not going out of the list. I will pass the order, and no adverse order to be there, because you are appearing.
Today it may not.
It may not reach actually. Today, if it reaches, I will mark your presence. No problem.
Tomorrow it may come.
The other Mr. Mohanty's matter and your matter, where the notice is yet to be returned or it is not, noting is not there, I have to verify and pass that order.
Yes.
Yes.
Item 14, my lord.
1-4.
Yes, my lord. That is
Fresh.
dispose of case, my lord. Your lordship have directed to the lower court, my lord.
You
This
see,
matter trial may be
again, Mr. Samantray.
I am for the opposite party.
Yes, it is a orders matter, so I can't take it up out of turn.
Sorry, my lord.
Wherever you want a specific date, specific adjournment, so that the list becomes less heavy.
Additional district judge file.
Suvilan.
Here is a case, Lord, additional district judge send an application for extension of time to complete the trial. That is the.
And that order has to be passed. That order has to be passed. Your government.
Yes, my lord.
Anyone present for the applicant?
That is not necessary, my lord. That is the dispose of case, my lord.
I understand, but when the petitioner is not there in their absence, and that order has been taken by the applicant there.
Yes, my lord.
This targeted whatever period. So in his absence, it will remain in the list. It will remain in the list. Yes. After recess then.
My lord, I permitted to.
Yes, please, Mr. Panda.
My serial number is 28. Possibly this present.
Yes, all matters which are not reached today will be again reflected in the list tomorrow.
That's
or maybe day after tomorrow it will be adjusted.
Today, I think we may be permitted to take 28.
Please you speak to the microphone.
It's 28 item. Possibly it may not reach because of the hearing case.
Correct.
So can we permitted to leave this court for today?
Yes, definitely, sir. No adverse orders in absence of the learned counsel when the matter is not taken up.
Problem.
Even if in presence of the learned counsel, no adverse orders to be passed. Yes. All matters where the learned counsel are not having difficulty or for any reason, they can leave. No problem.
Item number 8, my lords. May I pray, my lord, let it come after vacation.
Item 8.
8.
I did not appear in this matter for the opposite party.
Valmiki. Mr. Nayak was appearing in this case. Mr. Srikant Nayak.
No, this 2010. So 2010, I was. I was not. I was no more associated. 2010. All are 2010 matters.
No, 2010. Another is that has been tagged in 2000 matter. That is OJC to some 2000 in second item. Probably my lords was appearing in this in 2000 matters.
2000 matter. Yes, I was. But anyway, you want other side pen kya achanti?
Other side, Mr. Mahapatra is my lords. I will inform my lords.
Dayananda Mahapatra. D Mahapatra.
Dayanand Mahapatra. Last time he was appearing. Well, the file was transferred to Mr. Naik's chambers to Sierra House chambers and then my lords.
And last time Sierra was there. So apar kebe chauchandi eta?
After vacation.
After vacation date karantu. Achandi. 24.
Pardon, my lord, item 37, your lordship.
37.
Item 37. If both parties are present, your lordship, we prefer next week.
No date agree kar jantu. Please give a date so that
6 तारीख पे
6 kuch 6 he paribo.
Interim order may be continued.
You are Mr. Satpathy.
Parsuram Panda.
Mr. Parsuram Panda, Mrityunjay Banerjee. କେତେବେଳେ 6/5/25
Interim order may be continued.
interim order ଅଛି ତ?
ଆଜ୍ଞା ଅଛି.
Yes.
Item 10.
10.
My learned friend is for appearing for the petitioner in first two cases, and the third sub item I am appearing for the petitioner. Taken up on 13 or 14. 14, my lord.
Interim to be
Mr.
continued.
I'm sorry, I forgot your name, sir.
Gautam Patnaik, my lord.
Gautam, you don't have power here.
No, my lord.
କେବେ ଡେଟ୍ କହୁଛନ୍ତି?
13 mil.
ହବ 13. 13/5.
Interim order to be continued, my lord.
Interim order to continue.
In all cases, my lord, interim order.
ତିନିଟା ଯାକ କେସ୍ ରେ.
My lord.
ଆଜ୍ଞା. Yes.
In first two item, my lord, they have been directed to serve a copy. Now, my lord, I am received.
No, since I am not passing order, so simply add.
My lord. It is my understanding.
It will be acknowledged.
My lord.
Any other mention? So adjournment पूरा dictate कर दूँ अपन माने से काम सारे करीबे डाकों page wise adjournment जोड़ा है ची
Item 8.
Mr. D.K. Ponda for the petitioner opposite party blank it is submitted by the London Council for the petitioner that he has informed the London Senior Counsel Mr. D. Mahapatra appearing for the opposite party. ଆପଣ opposite party वाल्मी देखिए लिखिए for the opposite party और छाड़ दियो तो specify करो तो नहीं and the matter may be adjourned on consent list on 24/6/2025 तीनटा जाका matter अच्छी item 8 देखो
Item 9.
Mr. Devabrata Ratha for the petitioner. It was the S.K. Joshi. Mr. S.K. Joshi on behalf of D. Ratha for the petitioner. Anyone present for Mr. Sasibhushan Jena and Associates? Opposite party blank chat likhi diyo. The Learned Counsel for the adjournment is sought for. Adjournment is sought for on behalf of the Learned Counsel for the petitioner. The list on 8/5/2025 has prayed for.
Item 10.
Mr. Gautam Patnaik on behalf of Kaushik Ananda Guru. TRP CRL 73 side list achi list mark kar lekho 73 72 then TRPC 165 Mr. Tushar Misra hochunti petitioner. Mr. Gautam Patnaik on behalf of Kaushik Guru on behalf of the opposite party. The Learned Counsel for the parties seek for accommodation on consent list on 13/5/2025 interim order to continue.
Item 22.
Item 14 टा से अच्छा मेंशन करथिले तो लिस्ट रखिबे केते डाक्चन आइटम 22 page 6 Mr. Manoranjan Das for the petitioner, Mr. S.K. Behra for the opposite party. The opposite party की mention करथिले आपण थिले like mark कर opposite party blank छाड़ दियंतु. The Learned Counsel for the petitioner, Mr. Das submits that Mr. Jagannath Patnaik Senior Counsel has been engaged on behalf of the petitioner and the matter may be adjourned. The opposite party. As prayed for list on 26/6/2025.
Item 23.
Mr. P.K. Mahanti, opposite petitioner blank, opposite party P.K. Mahanti. Learned Counsel for the P.K. Mahanti, no. S.K. Sahoo on behalf of P.K. Mahanti. Appearance लिख ले. Learned Counsel for the opposite party submits that he has informed the Learned Counsel for the petitioner and the matter may be adjourned. Stop. as prayed for. List on 25/6/2025.
24.
Mr. Siddheswar Malik for the petitioner. Mr. M.K. Pradhan, Senior Panel Counsel for the opposite party. On consent, list on 9/5/2025.
Item 25.
25. Mr. S.K. Joshi for the petitioner on behalf of H.S. Misra. Mr. S.K. Joshi on behalf of H.S. Misra for the petitioner. Anyone present for the opposite party? Opposite party blank. Adjournment is sought for on behalf of the learned counsel for the petitioner on ground of personal difficulty. As prayed for, list on 24/6/2025.
Item 35.
Miss A. Annapurna for the on behalf of N.K. Misra for the petitioner. Mr. A.P. Ray, R.A.Y., A.P. Ray for the opposite party. On consent, list on 30/6/2025.
37.
Mr. P. Ponda for the petitioner. Mr. M. Banerjee, Mrityunjoy Banerjee, M. Banerjee for the opposite party. On consent, list on 6/5/2025. Item 40 ଅଛି. Interim order to continue. Interim order as dated so and so shall come till the next date of hearing. 37.
Item 40.
जो थी interim order थिबो कर दे. Mr. A. Mohanty for the petitioner, for the appellate. Mr. G. N. Sahoo for the respondent. Dita matter appeal अछि, dita के करना. On consent, list on 14/5/2025.
Item 2.
So rest of the matters, wherever any inconvenience to any counsel, please need not worry, because I mean I will be continuing this hearing, so the rest of the matters will be listed or it will be adjourned. Yes.
My lord, your lordships are able to hear me.
Sorry.
I said your lordships are able to hear me, so that.
Yes. The heights you have achieved, actually, it's difficult to attend for the microphone.
ओडिया रे अछि ना बड़ सन जे जो निकिति तौला बड़ सन को बड़ जे से रहे तळ को, so we always look like this.
I mean that's a nice way of putting it, but microphone to सेमती करा ही नहीं, कौन करे. In fact, तार गोटे base बाहर लेनी. In fact, this base was not earlier available. One box kind of thing, it is kept on that. So आपन को box अछि ना नहीं? A box अछि. Yes.
So whatever the plea, like the submissions made by my learned friend Mr. Mukherjee, I'll just. But first he said that misrepresentation, so far as my orders, like.
So the first thing is that you agree to that IA is under consideration.
Yes.
He submitted being a preliminary point.
No, my lord, there are two IAs.
Two IAs.
Amendment
11 and 16.
One is amendment. One is Order 7, Rule 11.
Yes.
So I will address your lordships because the amendment has to be taken up first.
Modification and
modification, recall whatever way you put it.
Not amendment. Amendment will come in after the.
No, I think the sequence is, my lord, the amendment, because if amendment.
Mr. Mukherjee.
Amendment of what?
He can't be that explicit. Even if a senior counsel, not bound by the but he can't be that explicit in telling that. So let him submit it the way he wants.
My only issue is that amendment that he is seeking, amendment of what? That is the question that I put to myself.
Yes, yes.
Because first of all, the suit has to come in existence. Thereafter,
Yes.
it can be amended.
Yes, yes, yes.
If the suit is not there, then what amendment?
So I'll address on the existence of the suit first, my lord, as my learned friend puts it.
So you carry on.
No, my lord, I'll come to that, then I'll go to the other aspect of the amendment. Now, your lordships may see Order 7, Rule 11, because that is the reason they say that suit is not in existence. First thing, my lord, while an application on Order 7, Rule 11 is filed, the court has to see only the plaint. Nothing less, nothing more.
And not the earlier orders even.
No, my lord, earlier order, so far as the procedural aspect is concerned, that is a separate issue, because once the defendant appears and files an application under Order 7, Rule 11.
No, I think, Mr. Mukherjee, you rely on Order 7, Rule 11.
Sorry,
You have filed today. No. Earlier.
Earlier,
that
that was being,
which is kept pending.
That was kept pending, and the last date, if your lordship sees that order of 17th.
Yes.
Can you take paragraph 4 onwards?
Or last order dated?
Dated 17/4/25.
Yes.
Paragraph 4, last learned counsel appearing for the defense admitted that since the plaintiff has failed to comply with the order dated so-and-so, passed in connection with IA number so-and-so, there is in existence no Admiralty suit as on date.
Yes.
He has relied on certain decisions in the context 49 of the code. He has contended that since court fees as determined by the stamp reporter of the court has not been paid till date and misrepresented the facts before the Supreme Court in transfer petition so-and-so, it is also submitted by Mr. Mukherjee, counsel appearing for the defendants, that the Honorable Supreme Court has already dismissed the transfer petition dated so-and-so. In such view of the matter, deficit court fees as directed by this court-wide order dated so-and-so having not been deposited, the suit itself is non-existing. So the order of release of the defendant vessel deserves to be passed. So suit is not in existence.
So in fact, again, para 4 will, I think you ask your learned associates to research on this, because the court in that order where it directed granted liberty to file or extended the time to file the deficit court fees without a exemption being sought for, what would be the fate of the interim order? So that was because the court is not very clear on that. The order is not very clear on that. In case of no exemption is sought for.
No.
It is only extension for filing of. So the plaintiff admits that there is deficit court fees. Ad interim ex parte injunction order, or here it's kind of a mandatory injunction order is passed.
No, let me go.
So
back.
what would be the consequence of that interim order? Because the court has so is there any provision that takes care, or any judgment law, or any decision?
There are. I'll give that in rejoinder. But before that, I would again remind your lordship. I began with the submission by bringing it to your lordship's notice, paragraph 35 of the plaint.
Yes.
Where it has been said that the full court fees has been paid.
Right.
And it is on the basis of that an application or a motion for interim order was made. So if your lordship looks at IS 7 and IS 6 separately.
So basically, actually, IS 6 is contrary to para 35.
Absolutely.
Para 35.
Absolutely.
So it is not that IS 7 is, IS 7 maybe has a context of 35.
It has to be read as a part.
But somehow that order does not take care of a situation where or on that day itself, maybe on IS 6 when the order was passed, that day itself 35 is not, para 35 is not compliant. Para 35 is not the actual status of the parties or the
not the correct fact.
Not a correct fact as far as 35 is concerned. 35 is concerned. So what would be the consequence?
my submission subject to what my learned friend submits and.
No, you can, no, please, you reflect on this and gather your thoughts. I don't want an instant answer. I do not want an instant.
I'll come back on
because you very clearly and categorically, refer to the IAs filed by the plaintiff.
I'll come back on
and
this.
Those IAs are after that 11, 16, 15, whatever has been filed, and maybe not.
And the order that was I read out to your lordship is in connection with my contention that the suit does not exist. It has become an honest in the eye of law. That is my order 7 rule 11.
What I have been thinking actually, the court is empowered enough to enlarge the period of deposit of court fee. Simultaneously, the court
exceptional circumstance.
Exceptional circumstance. Yes.
It's a discretion which has to be exercised.
Discretion to be exercised. Here, in absence of the suit being proper, not being the court fee not being paid. So, what are the ingredients of granting such relief of ex parte injunction, or like a mandate that it shall not be, it is arrested, and what could be the next order that is possible? Yes. So you just think about.
Address your lordship.
Yes. Yes. Order 11. Order 7 rule 11, Mr. Nanda.
Lord, rejection of plaint, what they are relying, your lordships must have gone through a number of times. Lord, the plaint shall be rejected in the following cases. C, they are relying on 1C, where the relief claimed is properly valued, but the plaint is written upon paper insufficiently stamped, and the plaintiff, on being required by the court to supply the requisite stamp paper within a time to be fixed by the court, fails to do so. Now, my lord, I take your lordships to Order 7 rule.
Just a moment. Yes.
Yes, my lord, 12. Procedure on rejecting the plaint. Where a plaint is rejected, the judge shall record an order to that effect with the reasons for such order. The reason being, my lords, it becomes a decree.
Yes.
So there is nothing called, my lords, automatic rejection of the plaint or saying the plaint does not exist. Plaint exists.
So in fact, 13, if you can complete reading 13.
Where rejection of plaint does not preclude presentation of fresh plaint. That is a separate issue, my lord. The rejection of the plaint only on any of the grounds herein before mentioned shall not be of its own force preclude the plaintiff from presenting a fresh plaint in respect of the same cause of action.
So even if it is a decree, if you say 12, so 13 is further can be
provides. So there is no issue or there is nothing which says that if the court fee is not paid within the fixed time by the court, the suit does not exist anymore. On the last occasion, my learned friend had shown the judgment which was deliberated before the earlier bench, my lords. That was that Nawab John's case. I take back your lordships. I don't know whether that was provided by my learned friend, which must be on record. 2012-6 SCR 369.
In the note you have referred today.
Yes.
The last also referred. Yes.
And they relied very heavily on this judgment.
Yes.
I'll take your lordship straight away to para 27, which is, my lord, internal page 396.
Yes.
Order 7, Rule 11 requires a plaint to be rejected inter alia, where the relief claimed is undervalued and or the plaint is written on a paper insufficiently stamped, and in either case, the plaintiff fails to either correct the valuation and or pay the right court fee by supplying the stamp paper within the time fixed by the court. Here, my lord, what I rely upon is the either correct the valuation. So that valuation is in the hands of the plaintiff. And
why do you find that in the order 7 rule 11 correction
my lord,
part?
That is the, my lord, Supreme Court's my lord, reading out it, because after that rule 13 has been mentioned, as your lordship pointed out. Para 27.
I think it is in the context of proviso.
Yes, context of the proviso, because it has to be read along with the section itself. Yes. Then, my lords, rule 13 categorically declares that the rejection of a plaint shall not of its own force preclude the plaintiff from presenting a fresh in respect of the same cause of action. However, section 149 of the code stipulates as follows. Yes. Power to make up deficiency of court fee, where the whole or any part of any fee prescribed for any document by law, yes, for the time being in force relating to court fee has not been paid, the court may, in its discretion at any stage, lordship may just highlight those words. Yes. Allow the person by whom such fee is paid to pay the whole or part, as the case may be, of such court fee, and upon such payment, the document in respect of which such fee is payable shall have the same force and effect as if such fee has been paid in the first instance. Okay. It can be seen from the language of section 149, it does not deal only with the court fees payable on a plaint. The said section also deals with every document with respect to which court fee is required to be paid under the appropriate law. It may be further mentioned that so and so, my lord, then therefore, when section 149 of the code speaks about a document with respect to which court fee is required to be paid, it takes within its sweep not only plaints, but various other documents with respect to which court fee is required to be paid under the appropriate law, including written statements in a suit. Then I take your lordships to the next page, where the earlier judgment was quoted.
Just go through para 28 also.
Yes, ma'am. Therefore, from the language of section 149 CPC, it follows that when a plaint is presented to a court without the payment of appropriate court fee payable thereon, undoubtedly the court has the authority to call upon the plaintiff to pay payment of the necessary court fee. Such an authority of the court can be exercised at any stage of the suit. It therefore appears to us that any amount of lapse of time does not fetter the authority of the court to direct payment of such deficit court fee. As a logical corollary, even the plaintiff cannot be said to be barred from paying the deficit court fee. There can be, in our opinion, be no doubt that section 4 of the Court Fee Act is not the last word on the subject, and the court must consider provisions of both the Act and the court to harmonize the two sets of provisions, which can only be done by reading section 149 as a proviso to section 4 of the Court Fee Act, by allowing the deficiency to be made good within a period of time fixed by it. If the deficiency is not made good, no possible objection can be raised on the ground of the bar of limitation. The memorandum of appeal must be treated as one filed within time, so and so, my lords. Then your lordships may come to the next page. Para 32. Yes. The question whether there is deficit of court fee paid with respect to a plaint depends on two factors: the valuation and the determination of the appropriate court fee payable thereupon. there can occur an error either inadvertently or otherwise on either of the above mentioned counts. Then the Tamil Nadu Act has been analyzed, then para 33.
Any perimeter provision in Odisha?
But to be honest, I have not checked that.
Section 4 of the Court Fees Act.
Court Fees Act.
Court Fee Act is in general.
Same.
So maybe the Tamil Nadu Act provided for certain contingencies.
Yes.
Court Fees Act ରଖିଛନ୍ତି ତ? Yes. Then the next page you are referring?
Yeah.
Beyond 32? Para 33?
33. 32, I have read out, my lord, that Tamil Nadu Act then comes after the first 4 lines. Then para 33.
No, because it says the para 32, the last line.
Yes.
If the court reaches the conclusion that the appropriate court fee is not paid, the consequences stipulated in section 12 to 4 should follow.
Yes.
So this 12 to 4 is Tamil Nadu.
Yes. And then it has been also, my lord, elaborated, and Lord, it may be the parameter provision I'll check up. If such conclusion is reached by the trial court is mandated to reject the plaint if the plaintiff fails to pay the necessary court fee even after being called upon, necessarily meaning that no adjudication on merits of the case can be made. The consequences of such a conclusion, if reached by the appellate court in the course of hearing of the appeal, are stipulated under section 12(4)(c), which is already taken note of earlier. This leads us to the next question regarding the legal character of section 149. Is it a provision conferring authority on the court to call upon a plaintiff to make payment of court fee which was found to be due but short paid on the plaint, or is it a provision conferring a right on the plaintiff to make good the deficit court fee at any point of time, irrespective of the provisions of law of limitation and other provisions and principles of law? We have already noticed that under Order 7, Rule 11, a plaint has not been properly valued, is the relief claimed therein or is insufficiently stamped is liable to be rejected. However, under Rule 13, such a rejection by itself does not preclude the plaintiff from presenting a fresh plaint. It naturally follows that a given case where the plaint is rejected under Order 7, Rule 11, and the plaintiff chooses to present a fresh plaint, necessarily the question arises whether such a fresh plaint is within the period of limitation prescribed for filing of the suit. If it is to be found by the court that such a suit is barred by limitation, once again it is required to be rejected under Order 7, Rule 11, Clause 4. However, Section 149, as interpreted by the court in Mananlal Supra, confers power on the court to accept the payment of deficit court fee even beyond the period of limitation prescribed for filing of a suit, if the plaint is otherwise filed within the period of limitation. Therefore, the rigors of Order 7, Rule 11 CPC and also Section 4 of the Tamil Nadu Act is mitigated to some extent by the Parliament when it enacted Section 149 CPC. Lord, then next is para 36. Lordship's got.
Yes, please.
Thus, this court on more than one occasion held that the jurisdiction of 49 CPC is discretionary in nature. It is well settled that the judicial discretion is required to be exercised in accordance with the settled principles of law. It must not be exercised in a manner to confer an unfair advantage on one of the parties to the litigation. In a case where the plaint is filed within the period of limitation prescribed by the law, but with deficit court fee, and the plaintiff seeks to make good the deficit, the court fee beyond the period of limitation, the court, though has the discretion under Section 149 CPC, must scrutinize the explanation offered for the delayed payment of such deficit carefully, because exercise of such discretion would certainly have some bearing on the rights and obligation of the defendants or the persons claiming through the defendants the case in and so and so. It necessarily follows from above that Section 149 CPC does not confer an absolute right in favor of the plaintiff to pay the court fee as and when it pleases the plaintiff. It only enables the plaintiff to seek indulgence of the court to permit the payment of court fee at a point of time later than the presentation of the plaint. The exercise of discretion by the court is conditional upon...
just a second, actually the page is missing now. It goes beyond page 402.
402.
My copy ends at 402 actually.
Oh, I'm
वहाँ पर पढ़िए लगे सीट लेकिन कागज़ पढ़िए जो उधर लिखा हुआ है.
Is the last page, my lord. 403, it's very.
What is the last page? Last page. Okay. So,
I would have copied Thibo brief review.
This is the last one. On the facts of the case on hand, the High Court recorded its conclusion as such. The subordinate judge has aided in allowing the IA number so and so by exercising discretion without analyzing the bona fides of the plaintiff's case and without giving notice to the defendant. Such a conclusion was recorded on the basis of the finding. Apart from that, sufficient cause was not shown, so and so. But now coming to another judgment, whether I can reduce the court fee for the purpose of, my lord, reduce or amend the plaint for the purpose of reducing the court. This is a judgment, my lord.
जो बाहर से स्टेपल करते हैं ना. Okay.
May I please?
Yes.
This is a judgment of the High Court at Hyderabad.
Yes. You have a copy on this?
Yeah.
Yes. Yes.
We have given them.
Umrao Devi Bantia.
Yes.
Yes. Yes.
Para 3, your lords. The petitioners herein are the plaintiffs in the above suit. They filed the suit against the respondents for declaring notices so and so issued by the respondent numbers 1 under the provisions of Act of 40 of 1977 as ultra vires, invalid and not binding on them, and for a perpetual injunction restraining them from interfering with the peaceful possession and enjoyment of the plain scheduled property. Respondent numbers 1 and 2 filed a common written statement. The third respondent filed a separate written statement. The respondents file IA number so and so seeking rejection on the plaint that the court fee paid was less. After contest, the said petition was allowed in part, and the petitioners were directed to pay court fee of rupees so and so, which they claimed as damages from the second respondent under a notice dated so and so. The said order was passed on 21/3/2007 in the suit itself, and the petitioner were directed to pay so and so on or before 4/4/2007.
No, yeah, so does paragraph 3 matches with the facts of this case?
I will, my lord. I'll show, my lord, that may be for a property, but the filing date, because they said that we didn't file it within time, because 4 weeks had lapsed. So the suit stands automatically dismissed or terminated, or suit doesn't exist as on date. So to that extent, my lord, I'll just...
No, here, which part actually, because it says that they filed their written statements also, para 3.
Yes. No, but this one, regarding the court fee only.
At any stage, court fee at any stage.
Para 4, the date. Because this was, because the last portion of that para 3, it says, the petitioners were directed to pay deficit court fee of rupees 3,80,000 so and so on or before 4/4/2007. Your lordship's got
yes.
The next. Thereafter, the petitioners filed IA number so and so on 11/4/2007 under Order 6 Rule 17 CPC, seeking amendment of plaint to delete subpara A of para 31 of the plaint by renumbering the subparas as so and so, by the date so and so in subpara of so and so so and so. In doing so, the petitioners sought to give up their claim in respect of their notice dated so and so, claiming the sum of rupees so and so from respondent by way of damages.
Yes.
They placed reliance on Section 12 of the Andhra Pradesh Court Fee Act and Suit Valuation Act so and so. The respondent numbers 1 and 2 opposed this application, and contended that
No,
without,
contended that they are at liberty to relinquish the claim.
yes,
Please mark this both.
deleted. Yes, both. My lord.
The
One
AC that said is not working.
no, my lord. This side is.
देखो Yes, please.
Opposed the application and contended that without complying with the order passed in IA number so and so and paying the deficit court fee, the petitioners had filed this application with an intention to avoid payment of court fee. They also contended that if the petitioners are permitted to amend the plaint as sought, they would be withdrawing the challenge to notice, also amount to withdrawing the entire case.
Yes.
They contended that a party who is not willing to pay the court fee has to be declared as one playing fraud on the court.
Yes.
Then, my lord, the third respondent also filed a counter contending that plaintiff is intending to take away the right accrued to defendants under the provision of law. And if the amendment is allowed, it would cause substantial prejudice to the defendants. By order dated 9/4/2008, the court below dismissed the said application. It referred to section 11 of the Act as well as section 12 of the said Act and held that neither of these provisions is discussed in the other provision and that no authority was placed before the court by petitioners that they are entitled to benefit of section 12 of the Act. It observed that the application is not maintainable under Order 6, Rule 17. It further held that without preferring appeal with regard to payment of deficit court fee, the present application has been filed and it is not at all maintainable. It observed that if the parties were allowed to delete the portion as per their wish, the orders passed by the court for collection of deficit court fee cannot be enforced at all. What my learned friend was stating, that the state exchequer will lose.
No,
And
if you
that
relinquish,
if a party did not.
No, Mr. Nanda.
I'm sorry.
This will help if you relinquish. I mean, what hinges. I mean, the entire thing hinges on the part that the plaintiff themselves relinquish the claim of rupees 7 crores 34 lakhs 53,522. Now the respondent comes up and says that if they relinquish, in fact, that is their contention also in para 7 they record. So I think if you relinquish the claim, then the answer would be different.
My lord, here the difference
yes, you are right in saying that it can be amended. It can be amended, but what is the amendment?
Amendment, my lord.
Amendment in the Andhra Pradesh suit is relinquishing the claim.
Here, because of, my lord, the difference between a normal suit and an admiralty suit which has been initiated two places. The initial application was filed before the Gujarat High Court on 11th of March. On 12th of March, I filed the application here and it is for the identical amount. And the same, there is no bifurcation, either they have sought for bifurcation there, here they have raised that objection. But they have not raised their objection even though they have filed their written statement. This is out of the only a single agreement. So that is why it is not that I relinquish my entire right for the claim. What I relinquish here is the claim before, in this suit before this honorable court, because that is arising out of one agreement. That claim already has been raised before the Gujarat High Court. So I don't want two decrees or two orders.
Then the most difficult part of the question is that both the suits are by you.
Yes.
It is not that they are not to a first suit or the second suit. It is not at their option. So if you rely on this decision is not partly helping you.
No.
Because now the court goes on to decide whether this notice seeking 7 crores some odd of money,
the amount is not paramount, whatever.
So whether because it is contended then in the reply to that particular amendment of pleadings or amendment of plaint petition is that if they relinquish the claim, then that alters the suit. Then perhaps the finding is that it is for the plaintiff to decide whether he will claim or not. The court say that since you have once claimed 7 crores, you are stopped from not claiming anything more or anything less.
No, it's not.
No, I'd say it is ex hypothesis. So perhaps on that premises, this decision is rendered.
So this is a normal suit. That is why I said
Then the normal suit, and also it has to be read in the context of the provisions of the CPC.
CPC. So here
So
the
dealing
difference
with
is
why this 149 and this it is and this order of 11 order 7 rule 11 have been provided. So in that context it has to be read.
yes.
But the case is much easier to understand in the facts, because they come up to file a suit in
There is a single
2007. A written statement is filed,
There is a single.
and post filing of written statement, they say that no, we relinquish. So basically they concede. They concede.
the other
side is not affected by that. The other side, against whom the claim is made of 7 crores.
Here, if I read their objection, what they have filed.
No, kindly let us finish this.
Okay.
Yes.
By order dated so and so, the court below dismissed, my lord, para 7. By order dated so and so, the court below dismissed the said application. It referred to section 11 of the Act as well as section 12 of the said Act, and held that neither of these. My lord, I'm sorry, I think I read that already.
No, you can carry on. A little bit repetition, no problem.
They are entitled to the benefit
Because
of
this
section
is the Act of Suit Valuation Act of Andhra Pradesh.
Yes. It observed that the application is
Yes,
not
that part is relevant.
Maintainable under Order 6, Rule 17 CPC. It further held, without preferring appeal with regard to the payment of deficit court fee, the present application has been filed and it is not at all maintainable. It observed that if the parties were allowed to delete portions per wish, the orders passed by the court for collection of deficit court fee cannot be enforced at all. Here, my lord, just pausing for a moment, I have already paid the court fee in the Gujarat High Court. It is not that I have not paid at all the court fee. In Gujarat High Court, ad valorem court fee is there, but it has been.
So that part actually I was telling you that whether this decision whether will help you in that to that extent. Anyway, please carry on.
Yes. The petitioner thereupon filed IA 28 of 2008 under Order 17 Rule 1 CP. I'm sorry, my lord. This is
XLB would be 47, I think.
47.
47.
XL. Rule 1 CPC read with section 114 CPC to review the said order. The respondent also filed counter contending that the review petition was not maintainable, that it was filed to drag on the proceeding without complying with the orders of the court. In the application filed seeking review, it was contended by the petitioner that the court had not considered the scope of section 12 of the Act, and when the provision of section 12 is very clear, the court cannot insist that precedents also should be cited. By order dated so and so, the trial court rejected IA number so and so, holding that the scope of review is limited and that it was the petitioner who had misunderstood its earlier order, and they have not made out a single ground for seeking review of its earlier order so and so. Challenging the said order, this revision is filed. But then it has discussed the that Order 23, Rule 1, then Section 11 of the Court Fee Act of the Andhra. Then your lordship may come to Para 19. Lordships.
Para 17 is also relevant.
There is relinquishment of portion section.
Because the section 12 of the Act, Suit Valuation Act of Andhra Pradesh provides itself.
For relinquishment. Even the CPC provides for.
Yes. No, Suit Valuation Act providing it is maybe in a different context of payment of suit valuation, court fee for the valuation of the suit. In what context this? Because I am not very sure about in what context 12, which chapter of the Valuation Act.
See the CPC also. There are provisions which says order to rule what may not, and then the order 23.
No, correct.
1. So
what I mean to say is that the Suit Valuation Act prescribes the procedure for payment of the court fee and valuation. So that itself provides that there can be a relinquishment of a yes.
Lord, your lordship may come to Para 19.
Yes.
Admittedly, on 21/3/2007, the trial court had directed the plaintiff to pay deficit court fee of rupees so and so in regard to the relief sought in the plaint regarding the challenge to notice dated so and so respondents, claiming rupees so and so by way of damages from them and directing the petitioner plaintiffs to pay the said amount on or before 4/4/2007. Since the plaintiff felt that continuing with the said claim would make him liable to pay so and so as additional court fee, the plaintiff was entitled under Section 12 of the Act to relinquish that part of his claim, as is being pointed out by my lord, of his claim, which if retained would compel him to pay the said court fee. The option to relinquish the claim can be exercised by the plaintiff as per Section 12 after he was required to pay the additional fee. Therefore, the court below was not right in ignoring Section 12 of the Act as well as Order 23 Rule 1 CPC and in holding that unless the plaintiff prefers an appeal with regard to payment of the deficit court fee, he is not entitled to seek amendment of the plaint for giving up the claim with regard to damages so and so as well as the notice dated so and so. It's reasoning that if parties were allowed to delete portions as per their wish, the orders passed by the court for collection of deficit cannot be enforced at all is clearly contrary to Section 12 of the Act. Section 11(2) of the Act states that if a party does not pay deficit court fee as ordered in the plaint is liable to be rejected. But that provision would operate only in a situation where the plaintiff, instead of abandoning a claim for which he has been asked to pay the deficit court fee, insists that the court deciding the suit claim, that is in a situation where plaintiff does not invoke option available to him under Section 12 of the Act, but where the plaintiff exercises the option given to him by Section 12, it is not open to court to refuse to permit the plaintiff to abandon a claim on which he was asked to pay on threat of rejection of the entire plaint invoking Section 11(2) of the Act. Then, my lord, I'll take your lordships to para 24. Since there is a clear error apparent on the face of the record, the said order is mentioned above, and for the above reasons, the revision is allowed. The order dated so and so in suit number so and so is set aside. IN number so and so is allowed. Consequently, the order dated so and so is set aside. IN number 6/2000 is also allowed. Accordingly, the revision is allowed. No order to pose costs. The court below is directed to per late petition.
There is no Supreme Court decision on this.
I couldn't, my lord, find. We searched a lot. There are 2 decisions of High Courts.
And the High Court, actually, High Court has confined to 12, the Section 12 of the Suit Valuation Act.
Because that was under the CPC only. Here, my lord, the difference is why I rely on this. There are 2 suits, but it arises out of one agreement. But I am forced to file in 2 different places because of this special provision of the Admiralty Act. Otherwise, it could have been at any place. Because the Admiralty Act requires me to file in a different place where the vessels are situated, which were part of the sale agreement or the properties of that sale agreement between the parties. So for that reason, I had to file here. It is not that I was filing in different courts of my own choice or otherwise.
No, actually, does filing suits at different places being mandated by the Act?
Yes.
Also, would result in a situation where you pay the court fee at one place and do not pay the court fee at one court.
I'm ready to pay for the rest of the reliefs that I have paid for, but for these damages, since I've already
because if you are very clear in your petition application that you relinquish your claim like this particular decision, then I think Mr. Mukherjee's answer would be different. Yes, Mr. Mukherjee?
If they relinquish their claim against the vessel, there is no
because this, so that is how again I'll just request you to whether this decision Umrao Devi comes to your help.
No, my lord.
Because Umrao Devi, the error apparent on the face of the record of the court says, in fact, the view of the learned trial court, the city civil court at Secondary is correct. That if a suit is filed and the court fee is not paid, so then incrementally say, let us achieve incrementally today to accommodate 1 lakh of court fee, one demand. Tomorrow, then another 1 lakh it is unable to pay, another demand. But here the High Court arrives at a finding that they can relinquish as provided in that paragraph, particular paragraph of.
No, my lord.
They have reproduced. They have reproduced.
Again, there is a difference. My lord, small difference. I'd like to point out. Is that
11.2.
Here the claim is a maritime claim.
Yes.
It's not a money suit per se.
Yes,
So
yes.
I'm not really.
No. I mean, maritime claim, but the prayer is for payment of damages.
Payment of
damages.
And
So,
other reliefs.
yes, your liberty to reduce the claim of court fee, demand of court fee by the court as per the stamp report in the process is a procedural part. You can very well say, relying on Umrao Devi, that yes, I have a right, I have the right to reduce it by relinquishing a claim. But you say that even if I do not relinquish the claim, since I have filed a suit at other High Court, I mean not High Court, not other
High Court.
Other High Court, what is that
That's
jurisdiction?
Admiralty.
Admiralty, other Admiralty Court having jurisdiction.
Yes.
So for that, I want reduction of the court fee.
No, I am foregoing the entire claim then suit. I have not said I per se don't have a claim against
Is there any part of your pleadings in the IA
I'll just
regarding relinquishment of the claim? Can you look at your IA?
No, not IA. The rule.
IA itself.
Yes.
In para 3.
IA you are referring to number. There are so many IAs. Please repeat the number.
15, my lord.
15.
1
5. Yes, please.
It has always been applicant's case that they have instituted.
You are reading paragraph?
Para 3 at page 2 of that application.
Page 2, para 3.
3.
Yes.
It has always been applicant's case that they have instituted arbitration proceedings against sanction. There is the owner of the defendant vessels on 20th February for inter alia their indemnity claim provisionally quantified at so and so, arising from the breach of this settlement agreement. Subsequently, on 11th March 25 and 12th March 25, respectively, the applicant invoked admiralty jurisdiction of both Honorable Gujarat High Court and this Honorable Court in accordance with the legal position that vessels may be arrested as security for an arbitration by instituting admiralty suits for a maritime claim in the court exercising admiralty jurisdiction. The plaintiff's maritime claim arises out of settlement agreement, which is a contract for sale of vessels and falls under Section 4(1)(r) of the Admiralty Act. The Admiralty Act is vessel-centric and requires an agreed plaintiff to go to different courts for the same cause of action. Accordingly, the plaintiff filed the Admiralty suit before the Honorable Gujarat High Court for its maritime claim rupees so and so for the arrest of the 5 vessels situated within its territorial waters. Now I have given the valuation of it. What would be the actual valuation of the 5 ships there? Thus, the total value of the 5 vessels in Gujarat is approximately so and so, leaving a shortfall of 128 crores so and so. Moreover, the values tabulated above are only market estimates and the factors. Therefore, in order to secure the entire claim, the plaintiff has also approached this honorable court for arrest of additional vehicles, the defended vessels that are within its territorial jurisdiction. The value of the defendant vessels which are located within the jurisdiction of this honorable court is as follows. Thus, the total estimate market value of the vessels, which when added to the value of vessels in Gujarat, covers the plaintiff's entire claim. The cause of action in both the suits is the same, that is breach of the same settlement agreement. The pleadings are identical, barring vessel-specific facts. The issues to be framed and the oral documentary evidence to be adduced will also be the same in both courts. This amendment seeks to reflect that reality clearly and transparently on the face of the plaint. While the plaintiff was alive to the issue and provided for transfer of terms of section 15 of the Admiralty Act, this could not possibly have been the Parliament's intention. That
So this particular IA, the prayer is for amendment?
Yes.
Or for reduction of the court fee?
The consequential will be the court fee because if my amendment is
So basically, actually, these pleadings are also not very clear whether you are relinquishing a part of your claim for reduction of the court fee. If you apply that to Umrao Devi test, Umrao Devi test says that yes, you have the option.
Yes.
12.2 whether is there or not, that is another part. You can check it because I am not Odisha. This Odisha rules and acts, whatever is there, Mr. Mukherjee will also check it. But in you seeking amendment for reduction of the court fee, if it is that explicit, if I may use that word, or that apparent, then I think the answer of the respondent would be different. They would not contest. Because there in Umrao Devi, they contested. Even they relinquish the claim of demand of 7 crores 58 lakhs so and so amount, they cannot. Because they want the direction to deposit of court fee, they are evading.
Yes.
And the court was impressed with the second argument.
No, this is
that they are trying to frustrate, or they are not depositing, or they are vying for time for the deposit. Only they are not depositing, and there is already a direction. Here, actually, factually the direction is already there. We have been discussing IS 6 and 7.
So it was there.
So it is there. So there, the Andhra Pradesh High Court says that 12.2 gives them a right of relinquishing and reducing the court fee. So that they say it's error apparent on the face of the record. So that is how maybe I think the court has not considered that particular finding of the learned trial court. That if they go on changing the claim and not pay the court fee, then what would happen to ultimately in normal course for a suit. That is one part. So that is that maybe some Supreme Court decision is there.
No,
but in your amendment petition, if you take advantage of Umrao Devi amendment to be allowed for reduction of the court fee, there has to be that that specific averment. No, Mr. Nanda, right now you don't have to answer that. No, you gather your thoughts on that. Because if you are so explicit in your statement in the plaint that it is apparent, or you can say it is only as far as this relinquishment of the claim is concerned, because your answer is, if I have understood, subject to you agreeing to that my claim is also at Gujarat. I am liable to pay the court fees there. I don't know whether you have paid court fees there or not.
We have already paid. That is not in.
And regarding this particular amount, whether you have paid there, and because for the 2 ships you could not have paid at Gujarat High Court.
No, we have already paid that. Because there different high courts have different rules. There it is the ad valorem court fee.
Ad valorem court fee, okay.
So there's a capping, fixed court fee. Like
fixed court, ad valorem, yes.
Gujarat has its fee. So that has been paid on this declared valuation.
That 428.
28.
Yes.
And just for a moment, my lord, pausing here, if your lordship should see the CPC.
Then just kindly, since you are going through that petition, IA,
yes,
that para 18.
Para 18.
Para 18 of your.
Before that, no, my lord, I was going through earlier. Now I'll take your lordship to para 15.
Yes.
While the plaintiff's transfer petition was dismissed on so and so, plaintiff has filed petition. However, on account of the time passed and though the review petition is pending, the plaintiff seeks to amend the present plaint to seek a declaratory relief and consequential relief of arrest and sale in aid of prior instituted admiralty proceeding before the Gujarat.
So this Mr. Mukherjee takes exception. I think his prima facie is right that this completely changes the nature and character of the suit.
My lord, subject to, my lord, what comes from your lordships. My lord, here is a peculiar issue. The very reason, the difference.
I just drew your attention. You can complete this. Complete this. I didn't want to interrupt you.
So then the prayer, as your lordships would, para 18, the following reliefs. In light of the above, the applicant seeks to amend the plaint filed in the suit before this honorable court to seek inter alia following reliefs. This court be pleased to declare defendant vessels so and so are connected with and subject of the same maritime claim arising out of or in connection with the transaction under settlement agreement as in Gujarat. Because there's a single agreement and there are different vessels and under different jurisdiction. That the defendant vessel so and so together with so and so within the term be arrested, detained, condemned and sold through bailiff under order so and so direction of this honorable court and sale proceeds be applied towards satisfaction of plaintiff's claim in the Gujarat suit. Because your lordships knows in an admiralty suit, the claim and in an arbitration and even in arbitration applications, the claim can be also indemnified through an admiralty suit. Because that is the peculiarity of the admiralty suits. Even the claims made in arbitration may be simultaneous proceedings. But for the purpose of satisfaction of that claim, admiralty suit can be filed, vessels can be arrested, sold, and kept as indemnification as against the arbitration or the arbitration. Then, my lord, the same is so far as the third C prayer is concerned.
That's why regarding the other vessel.
Yes. Then pending hearing and final disposal of the Gujarat suit, so and so, that is for the purpose of sale. That is, be restrained from sailing out of the respective ports or moving out of territorial waters until security towards plaintiff's claim in Gujarat suit is furnished. The pending the hearing and final disposal of the suit, this honorable court be pleased to issue a direction conducting the sale of so and so vessels by public auction. Then pending hearing the final disposal of the suit, the bailiff be directed immediately upon the sale of the defendant so and so to hold the sale proceeds on behalf of the Admiralty Registrar and to deposit the sum with the Admiralty Registrar the credit of the plaintiff's claim in the Gujarat suit after deducting the expenses of sale incurred by him. So these are the amendments which we have sought for and how the prayer to be read. Now, my lord, coming for a moment, what they have stated. Now, you'll also.
I mean, the apprehension is that these vessels will sail out of the Indian territorial water.
No, my lord, that is not an issue also so far as Admiralty suits are concerned.
No. In fact, I'm thinking like a lawyer actually. I mean, not exactly as a judge, because I don't find the reason of these successive suits at Odisha. First being without deficit, first agreeing to pay. As the facts have unfolded, who was advised or whatever, maybe the constraints of the client, that's another thing. But the fact remains that they agreed to pay, they institute a suit with a particular prayer, it's valued and it's not disputed also. Because in one of, I think, without appeal being filed of the valuation, the court cannot sit in judgment whether it is to be valued at a particular price or not, it has to be paid. That is one way of looking at it. But again, why the second suit here again in Odisha when the first suit is filed and it is rendered? It not rendered, it hits a roadblock.
My lord, the answer is, my lord, in section 4 and 5 of the Admiralty Suit Act. I'll just take back your lordships to that act again.
No.
Your Lordship may come to section 5, in fact. Of damages, it says as a security. If your Lordship should
Yes,
read
yes.
para 5.
Yes, because in 5.2, the maritime claim, you are saying maritime claim includes a claim pending in Gujarat. Pending in Gujarat. But in the suit filed here, that's not the prayer.
That is why, my lord, I sought for the amendment.
So exactly. So that's the so initially what was there, and you can very well file that suit, but insisting the same suit should be amended, and by reduction of the so suppose if you say that you are just read again that 5.2, providing security against a maritime claim. So what is the security against the maritime claim? Those two vessels?
Only vessels.
Only two vessels. So how the price will come down?
Price of?
The suit valuation. The suit valuation will come down.
No, because since I'm deleting that damages claim before this court in the present suit, because that valuation is already there in the Gujarat court. The 420 entire.
Yes, Mr. Mukherjee, they have deleted.
On the contrary, I read out paragraph 10 of the amendment application where they themselves say that as far as these two ships are concerned, they are 153 crores.
153 crore ad valorem, the court fee to be determined here.
Yes.
But damages, they have deleted.
No. Where have they deleted? Where have they deleted? They have not deleted at all.
Mr. Nanda, you take instruction on that. If your instruction is that you delete the damages here because of the pending suit in Gujarat, it has to come on pleadings.
All right, to that extent, I'll take instruction.
Then the rest part is 153 crores where you have mentioned in para 10.
Yes.
So how that is to be, though it is almost a, I mean, you can take those instructions.
I'll definitely.
If that be the case, if they have
then I think your answer would be different.
Then how can there be an arrest?
Arrest can be different. Arrest is completely.
I mean, I don't know what exactly would be the answer, because that's the advantage of being a lawyer, and the judge no more has that liberty of many things and addressing the court. So, but it would be different. Your answer would be different if they say that in the plaint itself that they are deleting the damages part.
Does it remain an admiralty claim at all? That is the question.
So that also I'll explain. It remains.
So you'll continue further, or after those instructions you will make your argument submissions?
Tomorrow, my lord, your lordship.
Yes.
Keep it.
IA 15 of 2015, 25. It is at flag I. First title जहाज से लिखी देवे. Mr. Mukherjee, I'll be requiring your assistance also because I'll be recording your submissions.
Certainly.
You started with IA 15.
I started with a plaint.
Yes.
Showing that misrepresentation with regard to payment of court fees.
The learned senior counsel, Mr. Mukherjee, submits that it's plenty for defendant. It's a suit. You can refer to the earlier orders. Kindly just in a piece of paper you give your appearances so that they will make correctly.
We'll do that.
Because they may get confused in writing that. You start with the plaint at page
17, para 35.
Page 17, para 35. 1735 ଆପଣଙ୍କର reference ପାଇଁ ଆପଣ ଯୋଉ margin ରେ ଲେଖୁନାହାନ୍ତି ଗୋଟେ doubt ହଉଛି ସେଇଟା ସେଥିପାଇଁ not that you'll write it. Yes. The sanction and underwater breach the settlement agreement that you are referring.
No,
para 35.
Para 35, where they say that the plaint is sufficiently stamped.
Wherein it has been stated that the plaintiff has paid a fixed court fee of INR blank into square brackets, and hence the present suit is sufficiently stamped. Then, Mr. Mukherjee?
Then, my lords, I pointed out to the prayer where there is a claim for 428 crores, 14 US dollars.
The Lawrence Senior Counsel then draws attention of the court to the paragraph captioned as prayer of the plaint. Para Roman I টা কোট করতে হবে। To submit that, a sum of rupees INR 428,76,87, 464.30 along with applicable interest per annum.
Now, my lords, as far as this value is concerned, this is the value of how has this value been arrived at? This value is the value of the 7 ships that day. 9 ships. Value of the 9 ships.
It is submitted. It is further clarified. It is further clarified that the said amount is arrived at as the value of the 9 ships which form part of the agreement.
The alleged agreement, because we don't admit the agreement itself.
Oh. Sorry, please repeat again. Arranged.
It's an alleged agreement.
The alleged agreement. Alleged agreement. The alleged agreement. Then, Mr. Mukherjee?
Then, my lords, I referred to section 149 application, that is IA number 7 of 25, wherein in para 11, they have again misrepresented that the court fee payable is 85 lakhs and we have paid 75 out of that. 75,000 out of that. Para 11.
The Senior Counsel refers to para 11 of IA number 7 of 2025. Which contains the following averment, oblique statement. Quote, it would be manifestly unjust to compel the plaintiff. ଆପଣ ମାର୍ଜିନରେ ପାରା ଆଉ ଆଇ ଗୁଡାକ ଲେଖନ୍ତୁ, ବହୁତ ଗୁଡେ ଅଛି, କନଫ୍ୟୁଜନ ହେବ। ଏଇଟା ଆପଣଙ୍କୁ ଯୋଉଟା ଆଇଟା ଲିଖିଛନ୍ତି, ପାରା ଲିଖିଛନ୍ତି ତ? It would be, ଆଜ୍ଞା, correct, para 11, page 5. It would be manifestly unjust to compel the plaintiff to pay court fees of approximately INR 85,00,000 in relation to a proceeding which will not be substantively heard by this honorable court. It is submitted. The stamp report made on 18th of March 2025 by the registry of this court at para 3 provides, para 3 indicates rupees 12,86,31,885 is payable, rupees 75,012 paid, full stop. Deficit court fee of rupees 12,85,56,873 not paid. Yes, Mr. Mukherjee.
Thereafter, my lords, I also pointed out in the IA number 7 of 25, wherein they have said that the balance amount would be payable after the transfer application is adjudicated or the arbitration award is made.
You are referring to prayer subpara English 3.
3, yes.
The learned senior counsel refers to the paragraph captioned as prayer in the IA 7 of 2025 that contains the prayer that the plaintiff be granted additional time and the question of payment of the remaining court fees be kept open till the transfer petition that would be filed by the plaintiff under section 15 of the Admiralty into bracket jurisdiction and settlement of maritime claims bracket closed Act, 217 is finally decided by the Honorable Supreme Court and arbitration proceedings are yes, Mr. Mukherjee.
I also pointed out that the discretion of this court to exercise powers under 149 was invoked to allow admission on payment of 75,000 only and to grant them time. They did not contest the
learned senior counsel referring to the order passed by this court dated 9/4. Order dated 19/3/2025 in IA number 7 of 2025 submits that the discretion of this court as invoked before the coordinate bench then taking up the suit by stating that rupees 75,000 has been paid as court fee and the rest of the amounts shall be paid as would be directed in the time as would be directed by the court by enlarging the time for payment.
But they did not contest the amount indicated by the office. That was accepted.
The IA number 7 of 2025 pleadings in the IA number 7 of 2025 disposed of by earlier order dated 19/3/2025. The prayers made in the said IA or any part of the plaint does not did not dispute. If it is disposed of, then it should be did not. Does not dispute the amount quantified to be the court fee payable. The paragraph 4, stop the paragraph 4 of the order dated 19/3/2025 in IA number 7 of 2025 is clear to the extent that on submission of the plaintiff, court granted 4 weeks time for payment of the deficit court fee. Mr. Mukherjee also draws attention to the part of the order that provides, quote, the registry shall report with regard to its filing and sufficiency before the next date. Yes, Mr. Mukherjee, next.
Now, even though we filed an application of stay on 24/3/25, they went on representing to the court that they would be paying the court fee within the time granted by the court.
As the events have unfolded, it is submitted. It is submitted by the learned senior counsel that as the events have unfolded thereafter, the opposite part, the defendants filed application 4th of March 2025 Is it numbered?
Yes, 8 of 2025.
IA number 8 of 2025 for vacation of the
order of arrest.
vacation of the order of arrest. Arrest. মানে বন্ধ হওয়া যাবে। Or dated 19/3/2025, passed in IA number 6 of 2025, in view of the clear mandate of the order as contained in IA number 7 of 2025, dated 19/3/2025. The plaintiffs continuously represented before this court in the subsequent proceedings that they are going to pay the deficit court fees
within the time fixed.
And directed by the court by order dated 19/3/2025. Yes, next. Mr.
The court fee was not paid within the time provided. An application under 7 Rule 11 was filed by us for rejection of the plaint.
It is submitted, the court fee was not paid by the time enlarged. Time granted by this court, that is 16th of
April
2025. And thereafter.
No, not thereafter. We had filed our application and
the application for rejection of the plaint was filed under rejection plaint
was filed on 9/4/25.
What was filed on 9/4/2025
for
in terms of order 7 Rule 11.
Yes.
Order 7 or O.7 R.11.
Yes. That is IA number
for rejection
11.
of plaint.
That is IA number 11 of 2025.
That is IA number 11 of 2025.
No application for extension of time was made.
No application, it is submitted. No application for extension of time granted for payment of deficit court fees was filed by the plaintiffs by this date, by the appropriate date, that is 16th of April 2025.
And even till date, no application for extension has been filed.
And even till date, no application for extension of time has been filed.
Now, they have filed IA number 16 of 2025 for modification of order dated 19/3, which on the face of it is barred by the law of res judicata.
It is submitted that the IA number 16 of 2025 filed by the plaintiffs for modification of, they want modification of the only IA 7 or also 6?
IA 7. Only 7.
Only 7.
Not 6.
Not 6. One particular sentence. Of order dated 19/3/2025, passed in IA number 7 of 2025, is misconceived, hit by res judicata, and otherwise is not tenable in view of the consistent stand of the plaintiff to pay the deficit court fee within the time fixed by the court.
And there is no case made out for exercise of jurisdiction, the discretion of this court
in one
extension of time.
Extension. It is further submitted that no case is made out for extension of, for exercise of jurisdiction.
Exercise of
discretion. Exercise of discretion for extension of time to deposit the court fee as directed earlier by this court.
And by IA number 15 of 25?
By IA number 15 of 2025.
They seek to amend the plaint, which is an abuse of the process, because in that case, it changes the nature and character of the suit and it does not remain an admiralty suit anymore. And the only attempt, the only motive for IA 15 is to avoid payment of court fees.
तो तब कौन लिखले status टा? Now, it is submitted that filing of IA number 25 of 15 of 2025 is abuse of the process of court in as much as the prayer for amendment is effectively is to change the nature and character of the suit. If such amendment is to be allowed, result in the suit no more remaining an admiralty suit.
And the only purpose of the application is to avoid payment of court fee.
At best, the purpose for filing of this IA is for delaying or not paying the payment of court fees. As undertaken, as determined by the court, undertaken by the plaintiff, and by the time, and the time granted by the court having expired.
So in these circumstances, I pray that
then the Supreme Court. Then
the Supreme Court transfer
go there.
application. In the meantime, the transfer application has also been rejected by the Supreme Court.
Senior counsel refers to the transfer application referred to by the plaintiff in IA number. Blank IA number blank filed before the Supreme Court. That is your note point. The paragraph kete note re.
That is the Supreme Court.
Or you have enclosed it here.
Serial number 18. Serial number 18 in my list of dates.
18 लिखता margin upon लिखो.
That is
on 7th of April 2025. The Supreme Court has dismissed the transfer petition. That order you showed to the
that is annexure EE at page 310 of I at 11 of 25.
Page 310, IA 11 of 2025. Into bracket annexure EE. The transfer petitions into bracket civil numbers 906-7 of 2025 filed by the plaintiff have been dismissed. Have been dismissed because these numbers have been dismissed. Therefore, the plea of extension of time till consideration and the decision of the transfer petition also no more survives. It is submitted that on the face of it, the value of the ship, value of the vessel remaining same. The court fee that would be applicable and determined on the value, said value cannot be changed at the instance of the plaintiff in any manner.
Because of the valuation given by them. They can't retract.
More so when the value has been given by the plaintiff themselves to be asked before this court. That forms basis of their claim and calculation of the payable court fee. Anything else, Mr. Mukherjee?
Yes, no. In India, state premises as I have submitted, the order dated 19/3/25, where my ship has been ordered to be arrested until further orders. So I would pray before your lordship that hence today onwards, that order of arrest should not be extended.
It is prayed. It is submitted that the plaintiff's, the defendant's prayer would be that the order dated 19/3/2025 directing arrest of the vessels of the defendant could not have continued after the date of extension of time to pay the court fee expired, more so
On 16th of April.
expired on 16/4/2025, more so after filing of the IA. Your IA is 11.
My IA is 11.
Filing of the IA number 2025 filed on behalf of the defendants. Yes, ସବୁଗୁଡାକ 25. ମୁଁ ଯୋଉଠି 24 ଡାକିଛି ସେଟା it's a mistake. 11/2025 at the instance of the defendants or modification of the said order, and it should not continue beyond today.
And the plaint is liable to be rejected.
And the plaint is liable to be rejected in terms of the order 7 O.7, R.11.
And my lords, on instructions, I'm making a further submission that till this issue is decided by your lordship, I can give an undertaking to this court that I will not sail out of the territorial waters of Paradip. But the order of arrest should be removed because that creates a lot of encumbrance for me. I cannot participate in any tender. I cannot. My operations are severely jeopardized. So I can give an undertaking.
Operations during your stay at the port or rest at the port.
Yes.
So why you are not filing that affidavit?
My lord, there is a particular rules which says how it is to be released.
No. That rule does not come into play.
My learned friend says
that rule does not come into play. We have argued this out. My learned friend was not there. My learned friend was not there at that point of time. The matter was being addressed by Mr. Parija at that point of time. He invoked rule. He was referring to Rule 38. Rule 38 has no application in the present case because Rule 38 will come into play if there is a final order of arrest which I accept. Here is a case where it's an ex parte order passed until further orders, affording me an ability to contest the order of arrest. And I am contesting the order of arrest, saying that the order of arrest itself is not sustainable in law. So Rule 38 does not come into play. Rule 38 will come into play where I accept the arrest. Yes, it has been arrested, correctly arrested under Admiralty jurisdiction. And however, I seek release of the vessel for use and for generation of further revenue. Ultimately, it will inure to both either of the parties.
So basically, since you have received the instruction, I am not recording it now because that may lead to further, divert from the issue. Or one thing. No, I understand. So you can take instruction whether you can file that affidavit here. You take your time and you gather your thoughts on that aspect.
No, that is only when as long as your lordship does not decide by application, because my learned friend wants to take further instruction and make submissions to your lordship, which will perhaps.
Umrao Devi
doesn't apply. It doesn't apply.
Since they are relying on Umrao Devi,
it doesn't have
so
no
they
application.
may say that we are relinquishing something. So maybe your response would be different to that.
Absolutely. Here they are not relinquishing anything. They want they want the sale. So what remains? And they want to use the Admiralty Court as a Section 9 court. This is not permissible in law. That is not Admiralty jurisdiction.
So where you have concluded, Datta? The learned senior counsel submits that he has received instructions regarding the orders that the defendant would pray before this court during subsistence of this particular admiralty suit, and may be granted further leave to address on the same on the next date. This much I am recording just in a kind of a nebulous language. or एमती गोटे लाइन लिखबे he has instruction to make further submissions. आपण जा लिखले बुझी पाले ना भूल भाल हैला हैं मत लागिला से आपण एक्सप्रेशन से लागुची आपण या लिखंतु you can write this way. The learned senior counsel submits that he is to make further submissions regarding the conditions that can be imposed are as far as arrest of the vessel is concerned during pendency of this admiralty.
No, pendency of IA number 11 of
IA number 11 of 2025. Leave granted. Leave granted. Yes. Now, Mr. Nanda, coming to your submissions. Yes, please.
First thing is, my lord, that section 4 and 5. It's an admiralty claim. And it is as a security, not as a monetary claim to be executed through this court as per se.
Mr. Nanda, learned senior counsel, in response. Senior counsel appearing for the plaintiff. 11 is filed by you or Mr. Mukherjee's client?
By me.
Yes. The opposite party in the IA. It 11 upon lecture. Opposite party in the IA 11 of 2025 filed by the defendant submits that section 5 of the Admiralty so and so Act, 2017. Admiralty into bracket. Pura ta likhibe. Copy paste karibe. 5 into bracket English 2. You are referring to
one the first
5-1.
5-1 the operating first part for the purpose of providing security against a maritime claim. The very section itself, the vessel
5 arrest of vessel in rame dash into English 1. The High Court may order arrest of any vessel which is within its jurisdiction for the purpose of providing security against a maritime claim which is the subject of an admiralty proceeding, where the court has reason to believe that dash then tinta chokki jo gap rahibo, then straight away we are going to 2 or any A, B, C, D, E, anyone.
No, that is Lord. So far as the entire section is concerned, I read out because the arrest when
purata quote kar diyo.
The entire section 5 can be quoted.
Section 5 into bracket English 1 A, B, C, D, E, then 2, then proviso. Provided that purata quote kar.
And section 4(1)(r) that my claim is a maritime claim.
4 into bracket English 1. The High Court may exercise jurisdiction to hear and determine any question on a maritime, against any vessel arising out of any dispute arising out of a contract for the sale of the vessel. The learned senior counsel for the elaborates. The suit is a
Magnification or create security as against the maritime claim.
They are referring to which particular
This section 5.
Section 5. Yes, 5 has been quoted. The suit is for indemnification and
for securing the claim.
And for securing the claim
in respect of the maritime claim.
Securing the claim, securing the maritime claim. Maritime claim.
Arising out of the.
It is a suit in rem as defined under the statute. Now coming to your IA.
Yes. For amendment.
IA for amendment. Yes. That is IA?
IA 15.
The Learned Senior Counsel then refers to IA 15 of 2025 filed by the plaintiff for amendment of the claim. He submits that such IA is maintainable. You are referring to any provision in this 17 Act or rules? Regarding, because maintainability is also raised.
Read with section 12 of the Admiralty Act and Rule 3 of the Orissa High Court Admiralty Rules.
Section 12 of the Act and Rule 3 of the Odisha High Court Admiralty Rules. He refers to you are relying on Nawab John? Or you are answering Nawab John?
No, Nawab John is regarding what they had said, that it is an automatic rejection. To that extent, Order 7, Rule 11. Nawab John has nothing to do with Order 6, Rule 17. So that was regarding Order 7, Rule 11. Since your lordships have confined it to the amendment part, so then that will not be applicable, because that is regarding the court fee, Order 7, Rule 11. Here what I say, my lord, that I can delete a part of my claim.
So you are basically relying on Umrao Devi?
Umrao Devi for a contextual aspect that
he refers to the decision rendered by the Supreme Court.
No, not Supreme Court. That's Andhra Pradesh High Court.
No, Nawab John I am also referring.
Okay.
Nawab John. In A. Nawab John, title into bracket, into square bracket 2012, colon A. Nawab John versus V.N. Subramaniam. Decided on 3rd of July 2012, colon into square bracket 2012, 6 SCR 369.
This is for the
to contain that the court has power. Apart from the court has power to exercise its discretion under section 149 of the CPC for granting further time for deposit of deficit court fee.
And there is no automatic.
Though it is submitted, though the defendants heavily rely on Nawab John regarding exercise of court's power and discretion as prescribed under O.7, R.11 for rejection of plaint. There is also a scope for the plaintiff to seek the discretion of the court for extension of time. Regarding the prayer made in the petition for amendment into bracket IA 15 of 2025, it is submitted by the Learned Senior Counsel that the plaintiff relies on the decision of the Andhra Pradesh. It is not Andhra Pradesh. It is on the High Court of Hyderabad. The decision rendered by the High Court of Hyderabad at Hyderabad in Umrao Devi Bantia. देखिए लिखिए कौन करिए colon देख लिखिए versus Union Umrao Devi Bantia versus Union of India. So पूरा party नाटा लिखिए. Decided on 9.6.2015. Then colon 2015 SCC online HYD 694. Colon देखिए 2015 into bracket 5 Andhra Law Times ALT 11. It is not called High Court of Andhra Pradesh. It is Hyderabad.
Now it has become Telangana. So that's why
Hyderabad is still continued.
No. It used to be Hyderabad.
No, here
it used to be Andhra Pradesh. Now Andhra Pradesh is at Amravati.
Acha.
So this is.
So that is High Court of Telangana, but they choose to call it High Court at Hyderabad. As High Court of
Hyderabad at okay. Kon likhle? LT11 tapore that the court has the power if to allow the prayer of the plaintiff if even if in effect it amounts to reduction of the quantum of claim resulting in reduction of the court fee calculated thereupon. Regarding the contention of the plaintiff in the prayer for amendment, he submits that the amendment is necessitated in view of the pendency of the Admiralty suit at Gujarat and in terms of Section 5.
The arbitration proceeding which has been initiated
and
also by my learned friend.
Admiralty suit at so and so place likely at Gujarat and in pendency of the arbitration proceeding initiated.
Initiation or pendency of the whatever. It has already been initiated.
Sought to be initiated at Singapore at the behest of the defendants.
No, they have said.
That's right. So you said something. I thought that you were pointing towards Mr. Mukherjee.
No, as I said, my lord, I also
at Singapore at the instance of the plaintiff. They submitted in view of the Section 5 of the Act 2017 to secure the maritime claim. To secure to change for providing for the purpose of providing security against maritime claim, pending at Gujarat, pending before the Gujarat High Court and in the arbitration proceeding at Singapore in lieu of the vessel now within the jurisdiction of this court. The amendment needs to be allowed.
And it doesn't change the nature and character.
It doesn't change the nature and character of the suit. For further hearing, list tomorrow. The matter shall retain its position in the cause list. Mr. Mukherjee I would add karibe. It is submitted by the Learned Senior Counsel that when the plaint or the suit doesn't survive, there is no question of bringing out any amendment. In view of the order dated 19 March 2025 in IA number 6 of 2025, which also itself forms part of the order passed in IA number 7. This one. So on consent list tomorrow.
I may be pardon your lordship. Lordship, item 29, your lordship. Tomorrow I.
Yes. I am keeping this whatever has been handed over.
I may be pardon.
Olga folder deki table upar nahi ja.
Any specific time tomorrow, or it will?
Time it will retain its position,
Retain.
but we have to accommodate the other fresh because
My lord, I asked.
this kind of a arrangement actually makes difficult for orders and fresh admission matters. But otherwise also it is not possible to take up the hearing matters also. I mean, it's kind of a...
That's strange.
Yes. Thank you so much.
I may be pardoned, your
for your
lordship. I
time.
may be pardoned.
To make a mention, your lordship.
Yes, Mr. Panda.
Lordship, I may be pardoned, your lordship.
Lordship, kindly see, peruse the last order dated 11.
No, be assured that no matter is going out of the list.
My lord, senior is there. They will take time for instruction.
So if no simple adjournment you can seek, but no orders. I can't pass orders out of turn.
My lord, senior.
You agree for a date and suggest.
Lordship.
Please suggest a date. Item 12 के पे
Day after tomorrow, lordship.
So exact date of tomorrow नहले date कर दियो. No, देखी दियो तो Mr. Vibhu Prasad Panda for the petitioner. Mr. Chandan Kumar Mahanti.
Yes, my lord, senior.
I'm for Union of India.
Your name, sir? Puni. ଆପଣଙ୍କ ନାଁଟା କୁହନ୍ତୁ.
Madam Chandan Kumar Mohan.
ହଁ ଚନ୍ଦନ ଡାକିଲି ତ ସାର୍.
Yes, madam.
ଚନ୍ଦନ କୁମାର ମହାନ୍ତି CGC.
Yes, madam.
CGC for the opposite party. ଗୋଟେ ଡେଟ୍ କରିଦେବେ ଗୋଟେ.
And Amarendra Prasad Rai for opposite part number 2.
Amarendra Pratap?
Prasad Rai.
Amarendra Prasad Rai.
My lord. For ESI Corporation opposite part number 2.
For OP2. କେବେ ଡେଟ୍ କଲେ? 5/5.
No coercive action till date, lordship. My lord, senior is there. He has
No, ସେଥିରେ IA ରେ order ଅଛି କି?
No, sir. Last talk,
lordship. That is your understanding. Picking up matters is not a good thing, Mr.
Kindly take it up tomorrow, lordship. I will satisfy tomorrow.
5 ତାରିଖ ଆସୁ ସେ action ନେବେ ଆପଣ କାଲି mention କଲେ ହବନି. It is not going out of
ସେଟା
list.
ଯଦି ବ୍ୟାଙ୍କ ଆକାଉଣ୍ଟ ନେଇ ଯିବା ଆଜ୍ଞା ସରିଗଲା ମୁଁ
ତାହେଲେ ଏଟା କାହିଁକି mention କରୁଛନ୍ତି?
କାଲି
ଆଜକାଲ ତ ସେ ତ list ରେ ରହିଲା ସେଟା.
ଆଜ୍ଞା list
Wherever there is urgency you want for a interim order, please don't mention. Mention kale it cannot be passed out of turn.
So extra copy may be solved because
that is between you. ଆପଣ ନିଅନ୍ତୁ ସେଟା ମୁଁ ତ I am not taking up. It is in the list.
My lord, item 16.
Yes.
Deficit court fee matter postal already paid.
Order has to be passed. Out of turn এটা হবনি. When it will reach, the order will be passed. Let me see if orders matter. I'll take up tomorrow. I'll do something. Tomorrow.
My lord, I may be pardoned, your
matter
lordship.
was kept pending for about 2 weeks. So that is how, yes. So be patient for tomorrow. Yes. Any other?
I may be pardoned, your lordship.
29.
Item number 29, your lordship.
Yes.
Kindly maybe adjourn to day after tomorrow, your lordship.
You are appearing for?
I am appearing for opposite parties in WPC number 14,000. 2018, your lordship.
Even if it reaches tomorrow, the same order can be passed. Why you are worried?
Lordship, though I am appearing counsel in behalf of the ICR, lordship. So
I understand, but it will be in the list.
But this is my respectful prayer tomorrow. Day
No difficulty. No difficulty. Since you are appearing in BC, you make that prayer tomorrow because the other side is not there.
Tomorrow I will not be available, your lordship. For that
I understand, but the other side is not there. I am taking it out of turn without notice to the other side. Please appreciate that.
Lordship.
If you are there, you can make that mention in VC. Let us see. If the other side is there, then I am serious. Only request is that please inform the other side in presence of him. I can pass that order.
Lordship.
He is not there. You are the opposite party. I am adjourning without notice to him.
Lordship.